must then weigh it and make findings as to whether there is sufficient evidence and make a recommendation and give reasons therefore. And so it is a quite detailed set of terms.
Sorry to interrupt you once again, but surely it has to be more than advice, because the Speaker could well have gone to legal counsel, could well have gone to attorneys and officials employed in the department. The National Assembly can do the same for advice. It should be a little bit more than an advisory opinion. Don't you think?
In the answer that I'll give to that is, it's undoubtedly clear from the rules read as a whole that it is an advisory body. Otherwise, one could not explain Rule 129(p)(2). The surely in your question goes to something else, and that is whether it should be more than advice. But of course, I've made my submissions on that. If the panel's findings and recommendation are binding on the Assembly, then you will be taking, if that is the finding of this court, you'll be taking out of the hands of the Assembly the assessment of whether there is sufficient evidence for the President to go on trial, and we submit that is inconsistent with Section 55(2) of the Constitution. We submit it is any such order with respect would entail an infringement of the principle of separation of powers.
Now, you accepted earlier in our discussion, Mr. Breitenbach, that the National Assembly's discretion should not be unfettered.
Sorry, would you mind repeating?
The National Assembly's discretion should not be unfettered. You accepted that?
It is not unfettered as a matter of interpretation.
And if this court were to say so, that would not be a breach of the separation of powers doctrine.
It would not, because the court would be interpreting a document and applying the ordinary rules of interpretation as developed in Cool, Ideas and Hubbard and the cases following it, saying this is what it means. You, the Assembly, have written this document, and it means that you have to consider the sufficiency of evidence.
Yes, my last question relates to sufficiency of evidence, and I apologize if this has been asked of you or of your colleagues before. What is the appropriate standard that the panel should have used? Sufficiency of evidence, prima facie case, or is it either one of those two? Is there a distinction between the two? If there is, what is the distinction?
So it's best to, although this falls more properly in the province of my colleagues, Mr. Budlander and Mr. Misquoted, I would obviously draw the court's attention to the precise wording of the relevant rules, which is 129(1)A and 129, so that's 129A, 1A, and 129G1B. 129(1)A refers to a clearly formulated and substantiated charge on grounds specified in Section 89, which must prima facie show. And my understanding of that and my submission is that one reads the charge and you ask yourself if all of the factual allegations on which it is based are correct. Does this show serious misconduct, serious violation of the law, etc.? And one can liken it to the scrutiny that we do every day as lawyers, where you look at a set of statement of claim or particulars of claim or a plea, and you read it and you ask yourself, do the facts alleged by the pleader prima facie, in other words, established on its face, but if established by the evidence supporting it, lead to the legal conclusion and the relief sought. It's an exception type assessment. So that's what's required of the Speaker. Very different as a line of questioning this morning from the court to my learned friend, Mr. Primia. The wording here is a recommend, and this is now 129G1B, a recommendation to the Speaker whether sufficient evidence exists. Now one looks at the underlying information, the information attached to the motion, any information which the panel in its discretion has sought from members, the President's reasons, and you ask yourself two questions. Does this point to the existence of evidence? Not information, but evidence. In other words, oral testimony or documentary evidence which can be adduced as proof. And the second issue, which is one on which evaluate, and it's an evaluative question, not an admissibility issue, is the sufficiency of that evidence. And it is, and my reticence, perhaps you would say egg dancing, around elaborating on that, is that it is something which requires a case-by-case and fact-specific assessment in any case. My learned colleagues will address whether Mr. Lamola and others got that wrong in their assessment of this particular matter.
Thank you, Mr. Breitenbach. Thank you, Chief Justice.
Mr. Breitenbach, just two quick questions. Just apropos what you've just said to Justice Theron, surely this panel is just a little more than an advisory body. It is surely, as the rules itself say, it's an initial inquiry, but it's non-binding on Parliament, the Assembly.
Certainly, except that to the extent that its inquiry entails information gathering in its discretion from members, it does determine the record, and it goes beyond that. In other words, the mechanism is, it's not a committee of Parliament or the NA itself which must undertake the screening function. It's left to senior people with the necessary legal competence and experience to do that. I accept that. But when it comes to its findings and the reasons for its findings and its recommendation, the rule is clear. It must substantiate what it says and recommends. But it is up to the Assembly to decide whether or not to do what is recommended. Let's assume, for counterfactual, that the recommendation was not to proceed to an impeachment inquiry, whether or not to follow that. And it's in that sense that I refer to it as an advisory body. It doesn't have decision-making power, and specifically the power to take the decision in question here, namely, there shall or shall not be an impeachment Section 89 inquiry.
And then just lastly, just a quick question. As I understand it, you don't quibble with exclusive jurisdiction on this matter. Thank you. Thank you, CJ.
Mr. Breitenbach, I have one niggling issue. I hope you'll help me. Is it correct to say, for as long as you have the majority in Parliament or the National Assembly, it doesn't matter whether the report is prima facie or the report mentioned prima facie or sufficient evidence? Put it differently, if the report that we have now had stated that it's based on sufficient evidence, it could still have been defeated on the basis of the majority vote. If that is the case, then there is a problem with the rule. Am I right to make that assumption?
With respect, I do not think you are correct for this reason.
Where am I wrong?
This court has said in EFF 1 and elsewhere that when voting on matters like these, it is what prevails is the responsibilities that members have as members of Parliament to the constitutional project. And specifically in this instance, they must show fidelity to the rules which they themselves have crafted, following the judgment in EFF 2, which require a decision on our submission as to whether there is sufficient evidence or not. It does not follow from that that in our system of constitutional democracy, where one votes for political parties who determine who represents them in the National Assembly, that parties may not caucus and that they may not have this debate, let's call it the sufficiency of evidence debate, behind closed doors before they have debate in open parliament. It is a matter which they are entitled as political parties, particularly the majority political party, but equally it goes for parties which are in the minority, to assess this question and to see whether there is agreement among them. Where it becomes difficult is if the whip is applied to members, and in the sense that members are told that they must go with the decision of the majority of the caucus on pain of being expelled from the party. If that has the result that members who dissent on that question do not vote with the party simply because of the whip, in other words, they do what this court has said they mustn't do, which is show fidelity to the party and not to the Constitution when dealing with important matters such as these, then that would be a problem. The question in this case, which my colleagues for the President and particularly the ANC will be dealing with, because it is a challenge frontally or squarely raised, is whether the evidence in this case shows that to be the case.
My second question is, does the issue relating to the sufficiency of evidence falls within your brief, or should it be left to Mr. Padlender and Mr. Mugaitobi?
On the fact?
Yeah.
My client is not engaged with the merits. They've left it to the political party and to the President, the ANC and the President, to deal with. So I'm unprepared to deal with that, and if you don't mind, I'll pass that hot potato to my left and to my right.
Perhaps before you do that, maybe they can eavesdrop into my question. If the test, as we have come to know, and there's a debate around it, it's sufficiency of evidence, and we know that the panel does not conduct oral hearings. Let's try and step into the shoes or the boots of the panel as to how can they make a determination as to whether this evidence is prima facie and this evidence is sufficient.
So
it's looking at the papers, statements and whatever.
Yes.
Is it something that you are prepared to answer, or I can leave it for your colleagues?
Well, that I would say, and my colleagues can correct me if they think I'm wrong, is the following.
I don't want you to muddy the waters.
No, I won't. If the question which is put to you, does sufficient evidence exist to show that the President has committed serious violation of the Constitution X? The first thing you ask yourself as you look at all of this information, you ask yourself, does it point to the existence of evidence? Is there a statement from Mr. Jones, for instance, a signed statement from a particular person who was an eyewitness, or can give relevant evidence to this impeachment committee in due course? Is there a document, the contents of which, if it's authentic, tend to show that, and which, if it's admitted, provide evidence? So that is why you have people who have to be experienced lawyers to look at this, because it is an assessment. It's a much more difficult assessment that needs to be done at a screening level, but not that different from what prosecutors have to do before they decide whether or not to prosecute. Is you look at the information that you have, you ask yourself, firstly, as I've said, does it point to the existence of evidence that can be adduced? And secondly, then the harder parts oftentimes is the evaluation of the sufficiency of that evidence. Is it sufficient to run a case, to prove a case which will show that?
Thank you, CJ.
Mr. Breitenbach, just one question. Seeing the purpose of these rules, that is to hold the executive, whoever that may be, accountable, how will it encroach on the separation of powers if this court gives some guidance to factors that the National Assembly should take into consideration when considering the process?
Let me make it plain that the separation of powers concern which I have raised derives from a series of judgments by this court, particularly the EFF 1 and EFF 2, in which the court has pointed out the problems with an existing. In the first case, it was with what happened in relation to the Public Protector's report, or what didn't happen more specifically. And in the second one, it was with the existing rules, the gap in the existing rule. I do not submit that a judgment by this court in which it elaborates on what's relevant and what would not be relevant when exercising the power under 129I3 would necessarily entail an infringement of the separation of powers. Where one runs into difficulty is when this court starts prescribing the details of the mechanism. And the thrust of the submissions that I've made today is that the rules say enough. I do take the point which Justice Colopin has made, that the rule on its face doesn't indicate, and one has to look at contextual factors and its purpose in order to arrive at the point that I've done in my submissions. But if your question is, if the court were to say that, and to say, well, that's relevant and that's what must be considered, and what you cannot do is take into account factors which do not go to the sufficiency of evidence, would that be an infringement of separation of powers? I don't believe that would be.
Well, one can go even further. This court can give guidance and then refer it back to the National Assembly to take those principles into consideration. I think then we've got a clear, then this court would have executed its duty and also respected the separation of powers.
Possible, but unfortunately, when this court speaks, its guidance, and understandably, is taken and must be taken as the law of the Medes and Persians, and it must be implemented because of the comity between the branches of government. And all that I would say in response to your question is that when one starts giving guidance as to matters of detail, one must bear in mind the Section 55(2) of the Constitution.
Thank you, Mr. Bracken.
Thank you very much, Mr. Bredenbach. Mr. Padlender.
Justice, would you give us a minute to just move sideways so that our colleague...
May it please the court, I'm going to deal with 6 matters, which are the following. Firstly, the question of delay. Secondly, exclusive jurisdiction. Thirdly, the fundamental error of the panel. Fourthly, sufficient evidence, or rather evidence. Fifthly, bad faith. And sixthly, the reasons given by Minister Lamola. If I have time, I want to briefly respond to what I submit is an underlying flaw in the approach of our learned friend, Mr. Katz. So to start with delay, in an attempt to avoid the obvious problem of delay, the EFF says this is not a review, it's an application for a declaration. As Justice Majid pointed out, that doesn't actually get them off the hook. But in any event, it's wrong. It is a review, and it's a review for 3 reasons. Firstly, a declaration is one of the forms of review, forms of remedy in judicial review. It's well accepted, it has been forever. A declaration is a remedy for a judicial review. That's, if you look at Baxter's book on administrative law, you see, look at the remedies that he lists, you'll find declarations there. Look at DeSmith's book on judicial review, you'll find declarations there. Look at Wade and Forsyth's book on administrative law, and you'll find they too, when they discuss remedies on a review, explain why a declaration is often a particularly effective remedy. It's at page 484 of the 11th edition. So the fact that a declaration is sought doesn't make it the challenge, not a review. Secondly, the relief sought makes it clear that what is sought is the setting aside of the decision of the National Assembly. If one goes to the notice of motion, which is at paragraph 5 of the notice of motion, at page 2 of the papers, one sees they ask for an order substituting the National Assembly's decision, alternatively referring the matter back to the National Assembly. In other words, they want it reviewed and set aside. Thirdly, Mr. Malema himself says in terms that the EFF seeks an order reviewing and setting aside the decision of the National Assembly. At page 51, paragraph 181, he says, for this reason, the EFF seeks an order from this court declaring that decision unlawful and setting the resolution aside. So it's a review. And we all know the consequence of that. It may not be unreasonably delayed. And we make the submission that the EFF has disabled the court from deciding the application because there has been a patently unreasonable delay. There has been no attempt to explain the delay, and there has been no attempt to produce facts which show why the delay should be overlooked. Then on exclusive jurisdiction, the core complaint of the EFF is that the decision of the Assembly was irrational. Rationality is an obligation which rests on all who exercise public power. It's not an obligation which is specific to the National Assembly. The analogy is this: if the President takes administrative action and he breaches praja, that doesn't bring the matter within the exclusive jurisdiction of the court, because the obligation to take lawful administrative action rests on all administrators. It's not an obligation that is specific to the President. Similarly, a challenge based on alleged irrationality doesn't trigger the exclusive jurisdiction of this court. The EFF does attempt to show that the application rests on a failure of the NA to hold the executive accountable, and that is a specific obligation of the National Assembly. But we say that the National Assembly has held the President to account. Firstly, the Speaker considered the motion, found it compliant with the rule, and referred it to an independent panel. The Assembly, through the Speaker, established an independent panel to investigate the matter. The panel conducted an investigation. The President was required to explain and justify his conduct in what became a public forum, effectively. The panel recommended that a Section 89(1) impeachment inquiry be proceeded with, and the National Assembly considered the recommendation and didn't accept it. So the procedures to give effect to Section 89 of the Constitution were operationalized and the President was called to account. The EFF's complaint, real complaint, is that it doesn't like the result or the outcome of the process. It doesn't say the process wasn't followed. It says we don't like the outcome of the project, of the process. Because the majority of the NA, by means of a vote, made a decision which it did not like. We say make the submission that that's not a failure to hold the President to account. We refer to what Chief Justice Zondo said in EFF 2 at paragraph 93, where he said, whether the National Assembly has held the President to account through a motion of no confidence in him or not cannot depend upon the result of the vote. You've held him accountable or you haven't held him accountable. The process was followed. The NA did hold the President to account in accordance with the rules. As to the exclusive jurisdiction of the court, we submit that the complaint of irrationality doesn't trigger the exclusive jurisdiction, and if the complaint of a failure to hold the President to account could trigger the exclusive jurisdiction, as a matter of fact and as a matter of law, the National Assembly did hold the President to account in accordance with the rules and the process designed for that purpose. That brings me then to the fundamental error committed by the panel. We submit that the rules create a multi-phase decision-making process. At each phase, there's a distinct question to be decided by a different decision-maker. Phase 1, the Speaker. The question the Speaker must answer is the motion compliant with the criteria set out in Rule 129A? Does it prima facie show that the President committed the impeachable conduct? That requires some consideration of credibility. It's not just enough to say, is it acceptable? Because, for example, if the complaint says the President, if a political opponent of the President died recently, and a complaint is laid that the President murdered his opponent, that would be an impeachable offense. But you've got to go further and produce some evidence to show prima facie there's something behind it. There must be something that will pass muster. That's the first phase. Second phase, the panel must conduct an inquiry. It invites further information from members, gives the President audi, and it must answer its question. It must recommend whether sufficient evidence exists to show that the President committed the conduct. Then the third decision maker is the NA. It must decide whether to approve the recommendation and send the matter to the impeachment committee. The matters the NA must consider are not specified in the rule, and its questions will be whether it is persuaded by the panel's recommendation, and if so, whether it considers that the impeachment process should be initiated. It's a large and far-reaching decision. It involves more than rubber stamping what the panel has recommended, even if the panel's report is flawless. The fourth decision maker is the impeachment committee. It must conduct an inquiry to establish the veracity of the complaint, and if veracity is established, the seriousness of the charges. So there we are now into veracity and seriousness, and must make a recommendation to the NA. And the final decision maker, of course, is the NA. Its question is, should the President be impeached? And so each time there's a different decision maker with a different decision. And the mistake that the panel made was to consider that it had to answer the same question as the Speaker. The panel did this despite the fact that the question the rules require it to answer is different from the question that the Speaker has to answer. The Speaker must answer whether the motion and the evidence, not just the motion and the evidence, prima facie show that the President committed the impeachable conduct, and the panel must consider whether there's sufficient evidence that the President committed the conduct. And the obvious questions are these, two questions. Firstly, why would the rules require two different actors to answer exactly the same question? What would the purpose be of that? Secondly, if Parliament did intend to require that these two bodies should answer the same question, then why did it use different language for each of them? It's a basic rule of interpretation that the use of different words demonstrates a different intention. It's got nothing to do with the situation referred to by Mr. Katz, where you have different countries having different standards for criteria for extradition, and a court has to decide whether they're equivalent. This is the use of different words in the same statutory instrument, the rules. And it's right that a court will hold that this difference signifies a different intention. And so we submit that the panel ignored the careful step-by-step process and ignored the fact that the rules require different actors to answer different questions. The sufficient evidence test, the prima facie test, is a screening or filtering mechanism, prima facie impeachable conduct. In contrast, sufficient evidence is materially weightier because now you've got more evidence in front of you, and because it's the trigger for a possible impeachment inquiry. And we say, with due respect to the panel, that it asked itself the wrong question, and you don't get the right answer if you ask the wrong question. Certainly, we submit, the Assembly was fully entitled to take the view that for this reason, amongst others, it would not approve the recommendation of the panel. There was nothing irrational or impermissible about that decision. The NA was performing its function as the third decision maker in a multi-stage process. And that brings me to a core submission which I need to emphasize. Ultimately, the question before this court is with respect not whether the panel's recommendation was right or wrong. This is not a review of the panel's decision. The question is whether it was lawful for the Assembly, after a debate and a vote, to decide not to approve the panel's recommendation and not to send the matter to the impeachment committee. Incidentally, in the end, the Assembly didn't strike down the report of the panel. It declined to follow the panel's recommendations. And the EFF has failed to show what was unlawful about this decision of the committee, of the Assembly. Then the question of evidence. The panel was required to consider whether sufficient evidence exists. Sufficient enough evidence, actual evidence exists, is in existence, not might be found if you conduct a further inquiry. The panel went beyond the evidence. It received and considered and reached conclusions based on, amongst other things, suggestions made, for example, by Mr. Fraser, allegations made by Mr. Fraser where he produced no evidence to support them, speculation and suspicions as to what the position might or might not be, statements by Mr. Fraser as to where there might be other evidence, and hearsay evidence which the panel considered without applying the well-known tests for when the rule against hearsay evidence may be deviated from. The panel relied on all of this material in reaching its conclusions. Again, the question before this court, we submit, is not whether the conclusions which the panel reached could be justified. The question is a fundamentally different one. It is, was the Assembly entitled to decide not to approve the panel's recommendation for this and for other reasons? The NA exercised its power as the third decision maker to decide not to refer the matter to the impeachment committee. We submit it was entitled to make that decision, and there was nothing unlawful about the decision. Then fourthly, bad faith. The prohibited conduct requires dolus. It is deliberate conduct by the President himself in bad faith. Again, in this context, we submit it's important to get the question right. The question is not whether the President acted correctly in all respects. It is whether, if he got it wrong in some respects, this is shown to have been deliberate and in bad faith. And that is most simply demonstrated by the debate in the report about the correct interpretation of paid work. The panel analyzed the question and it came to a conclusion about what the correct interpretation is. But even if one assumes for the sake of argument that its interpretation is the correct one, that doesn't answer the question whether the President deliberately and in bad faith adopted a wrong interpretation of the term paid work. The President's farming activities have never been a secret. He's published a book of photographs of the particular breed of cattle in which he has a particular interest. It seems very unlikely that he deliberately and in bad faith ignored the law and then publicized his activities. Perhaps more likely is that he genuinely thought that he was entitled to act as he did, and he lacked dolus and bad faith. Again, the question is not whether the President's interpretation was right or wrong, it is whether his interpretation was in bad faith. And again, the critical question is whether the Assembly was entitled after debate to decide for this reason, amongst others, that the matter should not be sent to the Impeachment Committee. That brings me finally to the reasons Minister Lamola gave for opposing approval of the panel's recommendation. And the EFF asserts over and over again that in assessing the rationality of the NA decision, one can have reference only to what Minister Lamola said in his speech. The first thing I note is that the EFF has caricatured what Minister Lamola said. What he actually said is summarized in the ANC's answering affidavit, supplementary volume 3, pages 862 to 868, paragraphs 68 to 70. Volume 3, pages 862 to 868, paragraphs 68 to 70. But the EFF, with respect, gets the point wrong. The test for rationality is objective, not subjective. It's not whether an individual, Minister Lamola, subjectively asserts a rational connection. It's whether objectively there was a rational connection between what was done and the power. And in the Mortal case, Justice Kampepe said this on behalf of this court at paragraph 69. She said, "The principle of rationality requires that every exercise of public power, including every executive act, be rational. For the exercise of public power to meet the standard, it must be rationally related to the purpose for which the power was given. It is also well established that the test for rationality is objective and distinct from reasonableness." Close quote. So the question is whether there is an objectively rational basis for the decision, not what the subjective view was of a particular decision maker, 1 out of 400, Minister Lamola. In any event, in this case, 214 members of Parliament voted against accepting the recommendation of the panel. One could never apply a subjective test to 214 people, find out what the subjective intention and reason was of each one of those. Each of them would have had their own subjective reasons and their own subjective views about the reasons for the decision. The speech of Minister Lamola was not an affidavit subscribed to by 214 members of Parliament, each of them saying, "These are my reasons and these are my only reasons." And so the attempt by the EFF to straitjacket the defense to this application into one part of what Minister Lamola said is simply wrong in law and wrong in logic. I need to make a key underlying proposition to all of this, which I wouldn't like to be lost, and that is when the National Assembly makes its decision, it has a residual discretion. This is addressed in our heads of argument in paragraph 61 to 62. The sorts of matters that the NA may consider in the exercise of its discretion are set out in paragraph 61. So then I do have time, to my surprise, to respond to what Mr. Katz said. I'm not going to respond to it in detail, to the what is actually a new case, which is attempted to make out in oral argument, and which it seems he's still trying to work out. I will make only one observation. His submissions with regard to the assemblies, his submissions deal with the National Assembly's carrying out of its functions, deal with them as if they were administrative action. For example, if political considerations enter their decision-making, the decision is invalid. Or for another example, if there are a number of possible reasons for the National Assembly's decision, one bad reason will invalidate the decision. Those are administrative law doctrines. This was not an administrative decision. This is not administrative action. It's also not executive or legislative action. This is the exercise of a sui generis constitutional power. It's a power conferred by the Constitution, which is neither administrative, nor executive, nor legislative. And you can't just import administrative law doctrines into this decision and say, because you've breached a rule in Paja, you fail to have regard to relevant considerations. You've made a bad decision. You've had a bad decision mixed up, bad reason mixed up with the good ones. Political considerations have affected you. We say this is administrative action, and it's not administrative action. It is a sui generis power, constitutional power. And then I need to deal briefly with this bogey that is raised of politicians making the decisions. The National Assembly consists of politicians, only politicians. The Constitution says that the politicians, these politicians, must decide on impeachment. The Constitution makers knew, as we all know, that they were conferring this power on politicians, not on judges or courts. They knew, as we all know, that when politicians make decisions, inevitably political considerations do weigh on those decisions. They are normal human beings. Political considerations weigh on decisions like impeachment, certainly, just like they weigh on a number of other things that they have to do. And they know that inevitably, we see it all over the world, impeachment has a political dimension. And that is why it is appropriate for the National Assembly and not the courts to decide whether the president should be impeached. And that is why the Constitution makers made that choice. They conferred the power on the National Assembly, a body composed of politicians. Now, there's a fine line to be drawn here. On the one hand, we know, and this court has told us, that if the politicians simply act on the dictates of their party leaders without applying their minds to their constitutional obligations, then they're not acting lawfully. We know if it can be shown that all that is happening is they're saying, what does the party say? Well, that's what I have to do, full stop. We know that that would be impermissible. But we also know at the other end of the spectrum that it is impossible when you're deciding on impeachment and when politicians are deciding on impeachment for political considerations not to carry some weight. And the power is conferred by the Constitution on the politicians. Now, where that dividing line comes is a very difficult one to find. And it does come, one's assisted with it. Justice told me if there's some criteria, I accept that. But the criteria are terribly difficult to define because you're at high risk, and the court is with respect at high risk of being overly prescriptive and then prescribing, doing things which are really the job of the Assembly under the Constitution, but on the other hand being so vague that no one knows what's intended and how to do it. And it's with respect, a very difficult question as to how one would draw that line. But we do say this, that if criteria are to be determined, they have to be broad, and we say that it would be wrong to prescribe that political considerations are irrelevant. It would be unrealistic, and it would be wrong, and it would be inconsistent with what the Constitution does, which is give the power to politicians. If the Constitution makers had wanted this to be a decision made on cold legal facts and cold legal decision making, it would have given the decision to the judges. But it didn't do that because impeachment is not just a legal process, it is also a political process, and there's no getting away from it, and we have to be realistic about that. And so the question was asked of our learned friend, Mr. Breitenbach. Let me put it this way. So what does the Assembly have to do when it considers the report of the panel? we say the question will be whether it's persuaded by the panel's recommendation, if so, whether it considers that impeachment process should be initiated. It's more than rubber stamping what the panel has recommended, even if the panel's recommendations and report are brilliant and unimpeachable and impeccable. Because if it was rubber stamping, then there would be no point in requiring a decision by the National Assembly. You could just give that power to the panel. But that would be inconsistent with what the Constitution requires. The Constitution requires the Assembly to decide whether there is impeachable conduct, or whether there should be an inquiry into impeachable conduct. And so, for example, let me give a simple example of this. Let's assume that the panel finds that the President's committed conduct which is impeachable. The Assembly may take the view that even though sufficient evidence has been found of that conduct, the conduct is not so serious that it should result in impeachment. And that's not a legal question, that's a political question. The conduct, the finding is made by the panel that the President has behaved improperly in some fashion. That's a matter on which lawyers, using well-known techniques, can decide and decide well. The question whether that misconduct, if proved, should result in impeachment is not a matter on which three very learned lawyers sitting in a panel have either the knowledge or the skills or the training to decide. It's a political question. And that's why the power to make the decision about impeachment is given to the politicians. And we say that so even at the first stage, even when the National Assembly reviews the panel report, one of the things it may say is we see the President has behaved very badly, and we see that it's been shown. But for this, impeachment is such a serious consequence for the nation as a whole that this is not the sort of conduct that justifies impeachment. That's a judgment you have to make, and we say, I make the submission that there is no basis for saying that that's something which is solely in the hands of the panel. It is a decision which is not purely a legal question, it is a policy or political decision. And that's why the power is given to the Assembly to decide impeachment. And that's why, as this court has held, it's the Assembly that must decide whether the matter should proceed to an impeachment committee. Because that, having an impeachment committee putting the President on trial is a far-reaching action with unpredictable consequences. And the politicians must take responsibility for those consequences. They must make a decision and they must take responsibility. And so for all those reasons, we respectfully submit that the application, the challenge to the decision of the National Assembly must fail. It is too late. It doesn't trigger the exclusive jurisdiction of the court. It's based on a fundamental error committed by the panel. It would be. It's based on evidence which is not evidence. It's based on allegations, bad faith, etc. And we submit that the application, insofar as it deals with the decision of the National Assembly, should be dismissed. Can I just say one more thing about delay? The question strikes one obviously. The decision was made in December of the National Assembly, was in December 2022. The review application was brought in February 2024. What happened? What happened, we know, is that an election was about to happen. And this was part of the EFF strategy. It's a legitimate strategy, and to advance its political cause. That's why there's such a delay, and that's why the application was brought when it was. It was brought not because of the December decision, it was brought because an election was about to happen, and this was an opportunity to make hay. Chief Justice, those are my submissions.
Thank you, Mr. President.
Mr. Butler, let us assume that the panel refers to prima facie or prima facie evidence, but in its definition of that concept, it defines it exactly as you would define sufficient evidence. As a matter of principle, would you have any problems with that?
No, we would have problems, Justice Madlanga, because in the context of this rule, prima facie and sufficient evidence plainly have a different meaning. And so the moment you say they're the same, you're setting off on the wrong footing. And so if you want to read the rule in its context, those phrases, those terms in their context, we say it's clear that they have a different meaning. And so it can't be done to say, well, I think they're the same. If you say, I think they're the same, and I deal with them as if they're the same, then you make an error.
I'm not just saying the panel would merely be saying they are the same. I'm going further and saying, in their definition of prima facie evidence, they go on to define it exactly the same way as you would define sufficient evidence. If you still have a problem with that, would that not be engaging in form over substance?
If the test they applied was sufficient evidence, properly understood, properly interpreted in the context of this rule, then there could be, I wouldn't have that complaint. But I would have a complaint, the complaint I have is that they say these two are the same. And the test applied by the speaker and the test applied by the panel are the same, and we say that can't be so.
Let us look at paragraph 75 at page 90 of volume 1, where the panel says this. In the
page
90. 90, as they would say at the bar, which I never understood.
I think that's what you do when you're throwing darts. Yes. Page 90.
Yes. There, the following appears: in the context of the scheme for the removal of the president from office, we therefore construe the phrase "whether sufficient evidence exists" to mean whether, based on the information received, the president has a case to answer. What problem do you have with that part of the formulation?
The problem is the next sentence. Put differently, we construe the phrase to require the panel to determine whether there's a prima facie case against the president. That's not correct. That's not what the phrase requires the panel to do. It requires a weightier decision, because we've had a prima facie case. Now the other members of parliament have been invited to put in evidence. The president has been invited to respond. There's a high-level panel required. It's given a month to try and do the job. It's a higher range activity than what the speaker is doing.
I'm sure you would agree, though, that what the panel says should be read cumulatively. Not so. Everything that it says in this context should be read cumulatively. Of course, it's something else altogether, whether you will then agree that even if read cumulatively, their reading of the rule is correct. But you agree that it should be read cumulatively nonetheless?
I'm not sure, Justice Madlanga,
let me just continue. Let me leave out the theoretical question, as it were. Let's go to 76, same page. We think the purpose in interposing the panel in the scheme of the impeachment process and entrusting it with the power to conduct a preliminary inquiry into the motion was intended to ensure that the President is not required to undergo a full-scale Section 89 impeachment inquiry in circumstances where the President has no case to answer. That step must never be taken lightly. It is a momentous act justified, and I emphasize what follows, only when sufficient evidence, your preferred phrasing, of course it's in the rule, not just yours.
Yes.
Only when sufficient evidence exists to show that the President has a case to answer for his conduct, and I stop my emphasis. The panel, therefore, functions as a filter to ensure that only a motion which establishes prima facie that the President has a case to answer is considered by the impeachment committee. Why does a cumulative reading of all that the panel says, why does this not satisfy what the rule provides for?
Well, the test in the rule is whether sufficient evidence exists to show that the President committed impeachable conduct. That's the test. Not that he has a case to answer. Sufficient evidence exists to show that the President committed a serious violation of the constitutional law, etc., etc.
The case to answer, but the case to answer relates exactly to what you refer to.
Well, that
is the itemized bases for impeachment, serious misconduct, and the other two. That's the case to meet, is it not?
Well, Justice Madlanga, the difficulty is that with due respect to the panel, it mixes the two concepts up, which are quite distinct. Read the last sentence of paragraph 76. The conduct functions as a filter to ensure that only a motion which establishes prima facie that the President has a case to answer is considered by the impeachment committee. 75, the panel to determine whether there's a prima facie case. We say that a prima facie case is something less than sufficient evidence to prove. Something less than that.
Let me move on to something else altogether. The question of the actual nature of the evidence.
Yes.
That is where your client complains, amongst others, about hearsay evidence and other forms of evidence that would, as I understand the argument, ordinarily not be acceptable in a court of law. As a matter of principle, must evidence that is admissible in a panel of this nature be the sort of evidence that is admissible in court and nothing less?
No, I wouldn't go that far. For example, if there was a signed statement, not on oath, the panel could surely have regard to it. If there was a document which on the face of it appeared to be genuine, the panel could surely have regard to it, even though there wasn't yet a chain of possession shown. So I don't submit that the panel is sitting as a court. It's not submitting as a court, and it's not applying the court's criteria, but it is having regard to evidence, and the evidence is broader than in an affidavit or sworn testimony, but it is narrower than suggestions were made by Mr. Fraser that what really happened was the following. With due respect to the panel, they had no business considering suggestions by Mr. Fraser as to what happened when Mr. Fraser had no knowledge and didn't claim any knowledge of what had happened. No, the panel had regard to allegations made by Mr. Fraser when he produced no evidence to support them and didn't say there was a witness who would support them and this is who the person was. The panel, with due respect, had no business having regard to those sorts of things. It went beyond, and it went beyond the extended notion of evidence which I say was permissible, Justice Madlanga.
Would you say the type of evidence admissible in, for example, commissions of inquiry would be the sort of evidence admissible before the panel or
Justice
not?
Madlanga, I don't like thinking about commissions of inquiry. Once bitten, twice shy. But yes, that sort of thing.
Would be admissible.
I would think so. I mean, I wouldn't like to tie myself to that precise definition because the courts have sometimes gone very far. The commissions of inquiry have regard to hearsay evidence very cheerfully.
Yes,
That
was exactly my next point.
I don't think a panel deciding whether there's evidence,
Yes.
sufficient evidence, can permissibly have regard to hearsay. I submit they could.
I will make the point regardless. With regard to the nature of evidence in commissions of inquiry, this is what Jafta AJP, who later became our colleague here, said in the matter of Bongoza,
Yes.
B-O-N-G-O-Z-A.
I seem to remember counsel quoting that case in Americana.
I'm very sorry. In that matter, here's what Justice Jafta says, relying on a submission by counsel, and this is paragraph 17 of the judgment. It says it was entitled to adopt its own procedure, that is a commission, including the receipt of evidence or information relevant to the issues before it. In fact, he contended further that the commission was responsible for collecting evidence and obtaining statements from witnesses. It could consider information of any nature, including hearsay evidence, newspaper reports, or submissions made without sworn evidence. For these submissions, counsel relied on Bell versus Van Rensbeck, S versus Mulder, S versus Sparks, and so on. Yes. And then in the paragraph that follows, Jafta AJP, having accepted the submissions, goes on to further strengthen the point himself.
Yes.
Why would that not apply to a panel of this nature?
I submit that the term sufficient evidence needs to be interpreted in the light of the context of the rule and what the rule is doing. The rule is about a possible impeachment trial of the president. And it's not like a commission philosophizing about its theory of the world. Some of them do that as well. It's a panel established effectively under the Constitution to consider the most serious matter, or a most serious matter. And I submit that the bar is set fairly high. It doesn't go so far as saying evidence admissible in a court. And a newspaper report, for example, something has been reported, you may be able to rely on it, I don't know. But whereas it seems from the authorities that a commission has pretty well carte blanche as far as hearsay is concerned, I submit that wouldn't apply to a panel of this kind.
The panel is somewhere in between.
Somewhere in between.
The court is up there, then panel, and then commission way below.
Precisely so, Justice Madlanga.
Thank you very much, Mr. Padlender.
Mr. Padlender, just on exclusive jurisdiction, you have submitted that we don't have that jurisdiction.
I beg your pardon?
You have submitted that we don't have exclusive jurisdiction. Yes. And it is because you are saying that what the EF case boils down to is that it doesn't like the decision that was taken by the National Assembly. And my question then is whether we should look, when we determine the jurisdiction, whether we have exclusive jurisdiction or not, we should look at the pleadings of the EFF. Yes. And if we look at the pleadings of the EFF, I'm referring you to 14.2, page 10 of the founding affidavit.
Yes.
14.2 says that in essence, the National Assembly has failed to properly consider the content of the report. So they are not saying that they are not happy with the outcome. They are saying that the National Assembly failed to properly consider the content of the report. If you can comment on that and say why the fact that they've made that allegation does not clothe us with jurisdiction.
Justice Chiki, I read that phrase as being a sort of administrative law ground, failure to have regard to relevant considerations, failed to properly consider the content of the report by effectively setting aside the panel's conclusions without establishing a factual or legal basis upon which to do so. That reads to me like a review challenge, that you made a decision without a legal or factual basis to do so. But I do accept that if the complaint is that you failed to hold the president to account, that triggers the exclusive jurisdiction, because it is the specific obligation of the Assembly to hold the president to account. We say that they did in fact hold him to account, but that's another question. But I don't, with respect, read this as making an allegation which falls within the exclusive jurisdiction of the court. It's not the exclusive jurisdiction of the court to decide whether bodies failed to do something without establishing a factual or legal basis upon which to do so. That doesn't fall within the exclusive jurisdiction of the court. Every day, cases are brought in the High Court in which the applicant's complaint is that the respondent failed properly to consider a report, didn't have a factual or legal basis on which to do what it did. That doesn't trigger the exclusive jurisdiction of the court. And if the complaint is that a president failed to properly consider a matter and didn't establish a factual or legal basis, that wouldn't trigger the exclusive jurisdiction of the court. It's only when the matter relates to a function which is specifically allocated to that decision maker, the Assembly or the President. That's what the jurisdiction of the court says, as I understand it.
I'm asking this question because we know that that report, which the EFF alleges was not considered by the National Assembly, dealt with the impeachment of the President. And this is why I then, struggle with finding that. And on your submission, this does not revolve around the issue of the President.
If it was formulated like this, then it might trigger the exclusive jurisdiction. If the complaint was that the National Assembly did not hold the President to account because it failed to properly consider the content of the report, then that might trigger the exclusive jurisdiction. This is more narrowly and described. If the complaint must relate to a specific constitutional obligation of the Assembly, and this is not a specific constitutional obligation of the Assembly.
Perhaps then it's because I'm looking at it holistically, because I'm looking at the fact that the real complaint is that as a result of them not considering the report, they failed to hold the President into account.
Yes.
And this is why I then thought that then we have exclusive jurisdiction, yes, because the real complaint is that had you considered the report, you would have held the President.
Yes, I understand that, Justice Chiki. I understand with respect to the point that you're making. And if it is formulated that way, then it may trigger the exclusive jurisdiction. But as you say, we have to have regard to the pleadings as they stand, and the pleadings as they stand don't make that case. They make a different case, which is that the Assembly failed to hold the President to account. They make that elsewhere in their founding affidavit. That triggers your jurisdiction. But the fact that the allegation that the National Assembly didn't properly consider the matter before it, doesn't trigger, I submit, the exclusive jurisdiction of this court.
Mr. Butler, we've heard wide and varied submissions, quite critical of the panel, both during oral argument this morning, and one can find much more evidence of that in your client's affidavit. And most of it, there's a basis for it. But it seems to me that looking into the future, it might always be quite easy to impugn a report of an independent panel for reasons not associated with the expertise of the panel, their diligence, or their industry, simply because of the convoluted manner in which the rules have been devised. So what the rule says is that the panel must conclude that there's sufficient evidence to show that the President has committed a serious misconduct, a serious violation of the law, etc. But then, having charged the panel with producing a report that contains sufficient evidence, it then restricts the panel considerably, because what the panel will receive only is information. Only information from members. It may not conduct an oral hearing, and it's limited to the written and recorded information placed before it. So it can't undertake what it's criticized for not doing, which is the proper evaluation of this information and to convert that information to evidence. Because ultimately, it cannot rely only on information. That information has to be elevated to evidence. And that would require some verification of that information. And so one almost senses the anguish of the panel. If you look at paragraph 94
Yes.
in volume 2, and that's at page 98. And while the panel is referring to Mr. Fraser's statements, I think they may well be a reflection of its general frustration. It says, while Mr. Fraser's statements provide information that may help to verify the truthfulness or otherwise of his allegations, the present process does not permit the panel to investigate these matters. So it has this information, but it may not investigate them. This, of course, does not mean that we must blindly accept the information contained in Mr. Fraser's statements in the hope that it may and probably will be verified. Nor does it mean these allegations must be ignored. So it sets up the two positions that it finds itself in. And then finally it says fairness dictates otherwise. But sadly, that otherwise is not to be found in the report. And so this may be a reflection of a structural difficulty.
Yes.
That panel, bring us evidence,
Yes.
but you're confined to information. And the panel tries to grapple with this at 94, but doesn't seem to provide an answer to it, except to suggest that the answer lies somewhere else.
Yes. So
would you agree that that's
I
a
do agree
systemic
with
issue?
that. I do respectfully agree with that approach, Justice Colopin. It seems to me the panel is given a difficult job because it's required to make findings about sufficient evidence when it's not really given all the tools which are necessary to find sufficient evidence, and then it has a finding which can have far-reaching and cataclysmic consequences. And so it's the panel's job is a very difficult one. And when we criticize it, we do it recognizing that. But the criticisms really don't go to the question of whether the panel did the best it could under the circumstances. That's not the issue. Or even whether what the panel found was right or was wrong. The question is whether the Assembly, when it decided not to accept the recommendation and said, well, I see all these problems in this report, was entitled to do so. And we say it was entitled to do so. It was not for the Assembly to say, well, the panel's job was a very difficult one, so I will overlook the many criticisms you could make of its report. That's not what the Assembly was required to do. The Assembly is making a decision about whether the President will go on trial. And it has to say to itself, is there a basis for that, a sufficient basis for that. And it's not, and the question is not whether the panel was right in what it said, and not even whether the Assembly was right in the decision it made. It's whether it was a decision that the Assembly was entitled to make. It had to exercise a judgment, a discretion. Did the decision it make fall within the reasonable range of what an Assembly could do? And we say yes, because there were these criticisms. Not a question of blame and pointing fingers. It's just there's a reality. The panel has to deal with the reality that the structure's awkward. The Assembly has to deal with the reality that there are problems with the report as a consequence. And it's entitled to say, well, I'm afraid this is not enough.
I accept that, Mr. Butler, and perhaps even in the context of this case, that may well be an outcome that is almost unavoidable, perhaps.
Yes.
But does it not raise the problem that the Assembly is entitled to say that this report is flawed in these respects, but in truth and reality, the origin of those flaws are the rules that the very same Assembly.
Yes, that's true.
So, you know, it's almost like, well, you can't have both your cakes and eat them. But what is your suggestion in terms of addressing that? Because you'll never have an impeachment. I mean, I might be just generalizing.
Well,
but if these
you'll have an impeachment when there is clear evidence of the offences.
But if the panel is hamstrung in coming to the conclusion that there's such evidence, because...
Well, sometimes you will. Sometimes there will be such evidence.
Sure.
Sometimes the complainant will produce such evidence, and sometimes the other members of Parliament will produce such evidence. It's quite conceivable. But one has to deal with the reality of the situation as it stands. I understand and with respect accept the point that you're making, Justice Colopin. But at the end of the day, the question that is before the court is, was the Assembly entitled to say, in the light of the defects and problems in the report, whatever the cause may have been, should we refer this matter to rely on this, to follow the recommendation to refer this to the impeachment committee and trigger something very consequential?
And our curiosity should not extend beyond that.
That is so, Justice. Well, we can be curious, but we can't all answer all questions, Justice Colopin.
Thank you, Mr. Butler.
Just one follow-up question, if I may. Mr. Butler, you said yes, there might be an impeachment if there's clear evidence. My question is, clear evidence determined by whom?
By the panel.
Sorry?
By the panel. Well, first by the panel and then by the impeachment committee. But if the panel has before it clear evidence of an impeachable offence, then there will be a referral to the impeachment committee, or there should be.
Is that the test?
No, I'm speaking colloquially about clear evidence, sufficient evidence.
So what if the panel says there is sufficient evidence? Should an impeachment, should it be referred to the impeachment committee?
No, the Assembly has to exercise its own judgment. It has to say, are there problems with this conclusion which the panel has reached?
See,
and secondly...
I'm just sorry to interrupt you. I'm just following up on the answer that you gave to Justice Colopin.
Yes.
Justice Colopin said that if that is the situation, there might never be an impeachment. And I just wanted to interrogate that because it seems to me there's merit in what he is saying. If we get, your answer was, yes, there may be, it might be referred to the impeachment committee when there's clear evidence. Now, who determines when there's clear evidence? Isn't that the nub of the problem that we're facing in this matter?
The panel makes a finding as to whether there's clear evidence, to use the colloquialism, and the Assembly must consider whether it's satisfied with that. It has to apply its mind.
So,
it's not a rubber stamp.
So your answer to Justice Colopin should be adjusted. Even where there might be clear evidence,
Yes.
in the opinion of the nationalist, of the report or of the panel, in terms of these rules, doesn't follow when there is clear evidence that there will always be referral to the impeachment committee.
And that is because...
And isn't that the difficulty with the rules?
That is the difficulty with the rules, but that's the difficulty with placing in the hands of the Assembly the decision whether there should be an impeachment inquiry.
And that's why this court must exercise an oversight function to determine whether the rules that are in place comply with what this court said in EFF 2 must be done.
Certainly, the court should consider whether the rules comply with what's in EFF 2. But what EFF 2 said in the passage referred to by a number of the justices this morning is that the Assembly must decide whether the impeachment process should proceed. The Assembly must decide whether there's a case which must be taken on impeachment. And if that's what the Constitution requires, then we are in a situation where the Assembly is entitled to second guess.
And is it the submission of the party that you represent that the Assembly should have an unfettered discretion in that regard?
Justice John, I don't have an instruction on that. I have my own opinions, but I don't think they'll be helpful to you. I don't have an instruction on that.
Thank you, Mr. Butler. Thank you, Chief Justice.
Mr. Butler, just two questions. Firstly, assuming we were to find that on a fair reading the panel's report addressed itself to the right question and found that there was sufficient evidence of impeachable conduct.
Yes.
But assume also that the MPs who voted to not adopt the report did so in the genuine but mistaken belief that the independent panel had not addressed the right question. Would it follow that the vote was irrational? You've told us that rationality is an objective test. So if a vote is based on the view that the panel has not addressed the legally relevant question, whereas it has, does it follow as a matter of course that the vote is irrational?
I'd like to think about that, Justice Rogers. If I can take it step by step, the Assembly, positing the Assembly forms the view that the state of affairs exists, but actually it's wrong. And is its decision then irrational?
Yes. If you wish to think about it and if the Chief Justice gives you an opportunity, unless you wish to answer it now.
I'd like to think about that, Justice Rogers.
My second question is this. Assuming the majority of the MPs in the National Assembly believed that the panel had addressed the wrong question, and assuming for the moment that perhaps the panel had got the test wrong, is it the right way for Parliament to proceed simply to reject the report? Let me give you a couple of hypothetical examples. Say that an impeachment motion alleging really serious conduct is referred to a panel, but the panel just doesn't report. It's delinquent.
Yes.
Presumably the answer would be, well, that can't be the end of it. You must then establish another panel. Here's another hypothetical example. There are 4 charges against the President that are referred to the panel, as there were here, but the panel only brings out a report on 2 of them. The answer would surely be, it must go back to the panel and they must give a report on those 2,
Yes.
the other 2. In this case, if the MPs thought that the panel had applied a lower standard of prima facie evidence, assuming that in the context of the report that was truly a lower standard than sufficient evidence, isn't the answer that the panel must then be required to answer the question, do they find that there was sufficient evidence? And for example, one of your criticisms, I think it is perhaps a fair criticism on the first charge, the earning of, assuming that one knows what the panel thinks on the interpretation, it takes a wide view that it includes being in a business where you are taking some decisions every now and again. Tell us why you think that rises to the level of seriousness.
Speaking for myself, I quite understand the panel's thinking on charges 2 to 4. But say on that one, they say, send it back because you haven't addressed the question of seriousness. Why was it legitimate for Parliament simply to put an end to this because the panel had apparently not asked the right question? Now, I appreciate perhaps that's not the way the relief has been framed.
Yes.
It's not the way the case has been advanced, but we may need to consider what happens in this type of situation, whether it's in this specific case or the future. It seems to me completely contrary to the notion of holding the President to the account that the panel's report becomes a game of forfeits, that if you can trawl through the report and find something where it's misdirected itself, that's the end of it.
Yes. I accept that, Justice Rogers. As you say, this, of course, is not the case that was brought and the case we've come here to answer. The case we've come to answer is a case that says the decision of the Assembly was irrational. If the case had been brought saying you should refer back, ask the panel to have another shot, answer the following questions, give us the following information, that would be a very different case, and one would have to think about the facts quite carefully. But and perhaps it would be helpful in relation to future matters if the court were to indicate that the consideration by the Assembly doesn't have to be an all or nothing business. It's not either in or out. You can refer back, engage almost in a dialogue with the panel. It would be helpful to say that, and that might facilitate the resolution of future disputes about impeachment. But it doesn't arise in this case, because that's not the case which we are brought here to meet.
All right, we'll take a 10-minute comfort break until 4:30, and that will give you time to mull over.
To try and find an
his
answer
first
to
question.
Justice Rogers in 10 minutes. That's very optimistic.
Sorry, what did I say? I'm looking at that.
Thank you. Thank you, Chief Justice.
4:10.
What time? It's now 4 o'clock. 4:10. Thank you, Chief Justice.
Amanda, Tio Makelela, Osizo Zabala, Zemazwele, Tio Zabala, Osio Zabala, Zemazwele, Tio Zabala, Osio Zabala, Zemazwele, Tio Zabala, Osio Zabala, Zemazwele. Aginezwa, Osio Zabala, Zemazwele, Sio Zabala, Osio Zabala, Zemazwele, Sio Zabala, Pae Chocho, Chocho Malema, Chocho, Wena Wisoja, Papaye. Chuchu Malema, Chocho, when we soja, when we soja.
Chio, RAMAPHOSA, Kumbula Emarikana, Wabula Lavandu, Yamahaina Ulindile, RAMAPHOSA, Kumbula Emarikana, Wabula Lavandu, Yamahaina Ulindile, Amahaina Ulindile, Amahaina Ulindile, Wabula Lavandu, Amahaina Ulindile, Amahaina Ulindile, Amahaina Ulindile, Wabula Lavandu, Amahaina Ulindile, RAMAPHOSA, Kumula Phala-Phala, Watengisangate, Amahaina Ulindile, RAMAPHOSA, Kumula Phala-Phala, Watengisangate, Amahaina Ulindile, Amahaina Ulindile, Amahaina Ulindile, Wabula Lavandu, Amahaina Ulindile, Amahaina Ulindile, Amahaina Ulindile, Wabula Lavandu, Elele Siloko Komiti, Elele Silawanda Ramyama, Elele Siloko Komiti, Elele Silawanda Ramyama, Elele Sichuchu, Elele Silawanda Ramyama, Elele Sichuchu, Elele silamanda banya. Elele silasunu titi. Elele silamanda banya. Elele silasunu firvote. Elele silamanda banya. Elele silasunu bosuma. Elele silamanda banya. Elele zijuju. Elele zilamanda banya. Elele zijuju. Elele zilamanda banya.
Agenda ya makapitale. The agenda ya makapitale. The agenda ya makapitale. The agenda ya makapitale. Abuya, abulalunya.
Was the vote influenced by an instruction to toe the party line? Question 1. Question 2. Were the reasons that were given by Mr. Namula rational, and were those the reasons that influenced the vote of the majority? Those are the two questions we need to answer. On the first question, which is there any admissible evidence of political party instruction or intimidation or threats? The EFF has produced no evidence whatsoever in support of threats, intimidation that resulted in this vote taking place in this particular way. They have referred to a statement that was published in the Sunday World, quoting Mr. Mantashe, where he states that the ANC has particular rules and that people should ask what happened to Ms. Makosi Khoza. But no evidence that this was ever communicated to members of parliament whatsoever. No evidence that he even went to the caucus, and if he went to the caucus, what he said at the caucus. So no connection has been drawn between the members of parliament who voted and the statement. And when you actually read the statement, it's actually useful to go through the statement. What you will find, and you will find that statement at page 146 to 147, you will actually find that it's not even a threat. What he says is that the NEC, which is the National Executive Committee, had given guidance. Those are his words, guidance. What you will also find is that that report also quotes other members of the ANC who say that they will vote contrary to a preferred party position. In fact, it says they were unfazed at the statements that he was making. So Minister Mantashe's statement does not come close to establishing an instruction or a threat. And then what was quoted today is a statement made by MP Phala-Phala, who tried to correct the record about how she voted and said, I want to vote in accordance with the party line. But there is again no explanation, no instruction, no evidence whatsoever about why she thought the party line is the correct line. What are the facts then? The facts are what the ANC has produced, and you have to admit those facts on Plascow-Evans. These are contained at page 853 to 857 of the record. What we know is that there were three bodies that made the decisions. One is the National Working Committee. The second is the National Executive Committee. Both in the National Working Committee and in the National Executive Committee, the President recused himself. And then the third is the ANC Parliamentary Caucus, which consists of members of the ANC in Parliament. Secondly, we know that the NWC met on the 4th of December 2022 after the report had been published on the 30th of November 2022. And in that meeting, the resolution that was taken was that the report would be voted against because of an intention by the President to review it. No politics. It's a pragmatic decision based on prematurity. We also know that the ANC obtained advice from senior counsel on the 5th of December 2022. Senior counsel concluded that the conclusions in the Section 89 panel report could not be used in their current form. After that opinion was submitted, there was an NEC meeting of the 5th of December 2022. That NEC also concluded that the report would not be supported because of pending judicial review proceedings. Again, a legal reason, not a political reason. In the morning of the 13th of December 2022, we know that the ANC Parliamentary Caucus convened in order to discuss its own position. Now, there are two things that are crucial in that meeting. Firstly, as pleaded by the ANC, there were dissenters. There were some members who said that they would dissent from the position of the from the position of the NEC. And those dissenting voices were merely noted at that meeting. We also know from the statement made by Mr. Philip Modise, who refuted as false the allegations of threats. We also know another member of parliament, Mr. Kobudile Janji, who said that the decision of the ANC was based on the balance of evidence, and specifically said that the members of the ANC would vote according to their oath of office and constitutional obligations. And so what emerges then from this narrative that is at 8:53 to 8:57 is the following. The NEC and NWC debated the report in the absence of the President, who recused himself. Their decision to reject the report was based on prematurity because it was at that stage subject to judicial review. Senior counsel advised the ANC that it would be premature to make use of the report in its current form. The Parliamentary Caucus considered the balance of evidence and noted the dissenting view of some of the members. So we ask you, Chief Justice and members of the court, to reject the allegations of threats as unfounded on the evidence. There were no threats, no unlawful acts of intimidation. Party discipline was indeed upheld, but personal conscience was respected, which is what this court requires. Then we must address the second question, which is, what is the substantive justification for the position taken by the ANC in particular? Now, we don't admit that one can come to court and challenge the ANC as such. It is only the National Assembly that can be challenged. But because much of the allegations in the founding affidavit relate to the ANC has decided to put the correct facts before the court. The position of the ANC is that it voted to reject the report in order to safeguard the impeachment procedure under the Constitution as such. It did so because it took the view that Parliament itself had to act lawfully. It could not merely rubber stamp the report of the Section 89 panel. And it is informed and inspired in that by the Nkandla judgment that I quoted at the beginning. That means that the National Assembly had the duty to satisfy itself of the lawfulness and the correctness of the report of the panel. What it did find was that the report was neither lawful nor correct. Why? Firstly, a debate has been held here about the distinction between sufficient evidence and prima facie evidence. But the consequences of this are much more severe than has been appreciated. We actually deal with them at paragraph 4.5 of our heads of argument. The panel is not a court of law, and so it's unhelpful to make references to standards in civil proceedings or in criminal proceedings. The panel is a tribunal, a subcommittee of parliament, a committee established by parliament. But this is why it's important. There are 3 stages that are crucial here, and at each stage, as Mr. Badland has suggested, there is a different evidentiary standard that must be met. At stage 1, which is the charge sheet, actually the rule 129 capital A1A refers to the word charge sheet. The charge sheet must disclose a prima facie violation. If the charge sheet does not disclose a prima facie violation, the Speaker has no jurisdiction to refer the matter to the Assembly. To refer the matter to the independent panel, to constitute the panel. And then at the second stage, once the panel has done its work under 129G1B, sufficient evidence must then be established. And then the final stage, which is the stage of the impeachment committee, what they must do there is not to establish prima facie, not to establish sufficient evidence, but they must establish the veracity and the seriousness of the evidence, veracity and seriousness of the evidence. So, when one was listening to the debate, one could easily make examples from civil proceedings. A pleading must disclose an action so that it is not excipiable. So one could think about a charge sheet which must disclose a violation so that it is not excipiable. But the evidence itself is a different matter, which the rule 129G1B seeks to import. And so, if the panel came to the committee, came to the National Assembly without making a finding of sufficient evidence, it fails to make a finding of sufficient evidence. What it is doing is that it is not discharging its mandate. It is not doing what is referred to in paragraph 4.5 of our heads of argument. We refer to this as a jurisdictional requirement. The correct language is jurisdictional fact. So for the Speaker to establish a panel, the jurisdictional fact is a charge sheet that discloses a prima facie violation. But for the independent panel to be established by the Assembly, the jurisdictional fact that is required is sufficient evidence. This court is familiar with this distinction from the judgment of Corbett J. in South African Defense and Aid Fund versus Minister of Justice. It's a long paragraph, but in the last sentence, he says, if the jurisdictional fact does not exist, then the power may not be exercised, and any purported exercise of the power would be invalid. So if we are correct, and we submit that we are, that there was an obligation on the part of the panel to establish a jurisdictional fact of sufficient evidence, and it failed to make that positive finding, then the Assembly had no power to constitute an impeachment panel. And this is why we have characterized this as a jurisdictional error. But it did not stop there, Justices. It went beyond, because it also did not consider the question of evidence, confining itself to information. You are right, Justice Colopin, that the panel must receive information, but it must process the information so that it casts aside what is not evidence, and then it leaves for the impeachment committee only evidence. So firstly, we have the wrong standard leading to a jurisdictional error, and secondly, we have the wrong standard leading to the failure to discharge a function that is assigned to the committee. This is why Minister Lamula, Mr. Badlander said Minister Lamula has been misquoted. He has been quoted correctly but misinterpreted. The actual statement is at page 956A to 956F, where he outlines the problems. He says, this is not a mere terminological problem that I am concerned with. It's not a mere terminological problem. I am concerned because as soon as they failed to recognize that they had to collect evidence, they did basic things. If you look at 956C, they reversed the onus of proof and placed it on the president. They relied on inadmissible evidence and media reports. And they were found to have been wrong in at least one. They concluded that Mr. Hazim is probably a fictitious person. And a day later, Mr. Hazim, a day after the report was published, Mr. Hazim surfaced with a very basic inquiry by Sky News. And they were not saying that this must be referred to the public protector. What they were saying is that, and you'll see this at 956D to 956E, they were saying the evidence is incomplete, it is premature, and there are other institutions that have powers to investigate, and they may unearth additional information. And then, insofar as the PRECA issue, they said the problem there is that you did not make a finding of bad faith. It was interesting to listen to the ATM referring to bad faith, not in relation to PRECA, because Mr. Lamula was quite clear about where the bad faith issue arises. It is in relation to PRECA. But in addition to that, there is a dense critique of the report that shows simply how bad it was. And it is given in the President's answering affidavit at page 351, 352, and 353. I just want to make three observations from that, and they correlate with what Mr. Lamula was concerned about. They say, firstly, the panel sources, and you'll find this at paragraph 77, there were two statements from the police and their annexures. And then there was also a confidential report by the Namibian police pertaining to a Mr. Emanuela David. There were also audio clips of interviews with either suspects, one suspect, or suspects. But these were incomplete. Get a statement which is supposed to be 20 pages, but it is 11 pages. And the clips themselves were incomplete. So you get a portion, and you don't know what came before and what came after. And then you also get the sense that all of this came from a single source, Mr. Fraser. And you also get the sense that there was access to Namibian reports which are marked confidential, and you have no explanation whether these were stolen from the Namibian police or not, because the custodians of those reports were not before the court. And you have no sense when you get the statements what else was available in the context where those statements were pulled out of the Namibian police. So in these circumstances that the ANC said, let's put a bit of caution. Impeachment is serious business. If we are going to subject the head of state to this process, let us do at the very least two things. One, we need some comfort about the source, reliability, credibility of the information that we have in front of us. And two, we also need to make sure that the panel has acted lawfully and constitutionally. Those are the fundamental justifications given in the answering affidavit. So you will see I've referred to Mr. Lamula's speech, and the court will take that into account. In summary, therefore, we say the ANC took the view that subjecting the president to a process of impeachment is a serious business. It is so because necessarily there is interference with the democratic choice of the voters. The voters have asked the man to run the country, but for weeks and perhaps months, he will now be cross-examined in an impeachment hearing. And at the outset, you must have jurisdiction to impeach. You cannot fix an alleged violation of the law by breaking the law yourself as Parliament. And therefore, a president should not be subjected to an impeachment on a whim, nor should an impeachment be used as a fishing expedition. Thank you, Chief Justice.
Mr. Mugato, colleagues.
Mr. Nkatobi, are you suggesting that the panel's report, despite the criticisms that may be legitimately leveled against it, would fall into either the category of a whim or a fishing expedition?
Yes, especially because the evidence is incomplete. And when Minister Lamula says, you are asking the president to hang himself because you've inverted the onus of proof, you said it's up to you to explain. That is a fishing expedition. And that is what he said in Parliament.
Could I just ask this, because I've been battling with this as well. The panel concluded that the president had a case to answer, correct?
Indeed.
The president takes issue with that because it says that's not the correct process to follow. That here's evidence, and you, Mr. President, must rebut it. The president says the panel must look at the totality of all the information before it and come to the conclusion that indeed there is sufficient evidence of serious misconduct.
Yes.
And therefore it misdirected itself in terms of the process that it followed.
Yes.
So in that regard, are you saying that the question of whether the president had a case to answer is not the question?
That is an irrelevant question. It is part and parcel of the misdirections of law that were committed by the panel.
And then just finally, you heard the exchange between myself and Mr. Butlander with regard to the perhaps inherent and structural problems that the panel may have faced. Not all of the criticism could be ascribed to that. But is that something that this court should be concerned about, whatever its decision may be on the merits of this application?
Not in relation to the resolution, because the structure of these rules, they make perfect sense despite their attempts to undermine their structure. The panel is not to be restricted in what it can collect. It needs to collect information. But
it's restricted from who it can collect it, not so?
Yes.
Only from members?
Yes. Well, it got information in this case from Minister Zungula, MP Zungula, who had attached a lot of non-member information.
Sure.
So it did take that into account as well.
But then you run into the problems of hearsay, not so?
Yes. Yes, then it runs into problems because there's no limitation on the quality. It must be information, not evidence. So at the point at which it gets it, there is no requirement. But it goes through a process of sifting it and taking out what is not evidence and then leaving only what is evidence. What it cannot do, it cannot collect everything and then say, oh, well, here it is. When it does that, it's acting in error of its mandate.
Can I just test, and this relates really to charges 2 to 4. I won't try to distinguish between them too carefully. What point you say, and for what reason you say there is not sufficient evidence. Can we accept that General Roeder was in the Presidential Protection Unit?
Yes. No, let me just go back to Justice Rogers, to the actual report, because in fact I did want to deal with this.
Well, perhaps I can just ask my questions and then you can go back to the report.
Yes, yes.
If he was, could the panel also accept that it was no function of the Presidential Protection Unit to investigate the theft of money that Mr. Ramaphosa or his corporation may have suffered in its private capacity?
Well, let me go back to the report.
Sorry, it's a straightforward question.
Yes, yes, I am going to answer the question, but I do need to explain precisely the submission I'm making. So you go to page 137, well, 10 to 138. And you will find this everywhere, actually. 137, paragraph 238, and you will see there that the conclusion they reach is prima facie. You go to 138, 239, prima facie, and then you go to the charge 2, and you will find there the conclusion at 145, also prima facie.
But prima facie evidence. In other words, evidence which, if it is not answered, may establish the charge.
Yes. Well, it says in paragraph 264 where the actual conclusion is that this information discloses prima facie. So it's prima facie information, not prima facie evidence. So
all the panel can receive is information.
Yes, but...
Can I ask you, I'm breaking away from my sequences of propositions, but...
Yes.
You question the information about Namibia. Would you say that that would amount to evidence if the whole transcript and the whole audio clip was there as opposed to only part of it?
Well, there are two criticisms that were actually put by Minister Lamula. Number one is this criticism that unless you know the full train, because you have, that's the one. The second one is distortion. In other words, it's information that is misleading. Even if it's evidence that is misleading.
Well, one doesn't know it's misleading. You say it may be misleading if you had everything else. All I'm saying is if you had a full transcript and a full audio clip as to part of it, as opposed to part of it, would you say that that would then be evidence?
Yes, if it was clear that it would meet some standard of admissibility. That's why they call it evidence. And no, it's not a court, it is a panel. But firstly, it must meet some threshold of admissibility. And secondly, it must not be cherry-picked. And those were the two criticisms.
Well, of course, we don't know it was cherry-picked. All we know is that perhaps it was what Mr. Fraser had.
Well, what we know is, if you can go to page 351 and 352, which is the analysis by the President of the information. .1, 77.2, 78, and 79. So you will see there that there is a problem about the incomplete nature. There is also a problem about the reliability.
But we must also take into account the, and it's been raised with you and your other colleagues by Justice Colopin and others, the panel is to some extent shoehorned into a process which must be finished within 30 days. It has no proactive powers to seek information. It simply evaluates information that has been given to it. But let's leave that to one side. I accept your proposition is that maybe the full transcript and audio clip would be evidence, but not just part of it. But anyway, if we can just continue. So,
well, Justice Rogers, no, I don't say that they should have got the full transcript. I say that if the panel wants to make a recommendation that there is a prima facie, there is sufficient evidence, it can disregard information that suffers from these defects and then only take forward that information that it would be satisfied would constitute sufficient evidence.
Or it may say, well, I've read what I've read in the transcript and I've heard what I've heard in the transcript. It may not be complete, but on what I have, it constitutes part of the evidence. But let me just carry on. So General Roeder was in the Presidential Protection Unit. It was no function of that unit to investigate the theft of President Ramaphosa's private money. And I assume you would accept it would be a serious abuse of power for the President to allow the people.
Sorry, Justice Rogers, I'm not waving at you. There's just a fly that is refusing, that is just refusing to.
I'm sure you're not trying to
refusing to disappear.
It would clearly be an abuse for a president to allow the presidential unit, protection unit, to, as it were, on the clock, use its to go and investigate a private theft. I mean, there could be no doubt about that, surely.
If you did so mala fide, as required under the rules, and what also there could be no doubt about, whatever quibbles we may have as lawyers about the correctness or incorrectness of the Section 89 panel, the true question is members of Parliament acting rationally with the information at their disposal.
Yes, now I just want to find out for what there was and wasn't evidence. The next thing is, it seems to me to be common cause that no case of theft was ever opened in respect of this amount, which totaled in rands about 8.7 million.
Well, what we know is that he says, the President, I'm not acting for him, he says that he reported it to his head of security.
Yes.
And it was up to the head of security to open the case.
The head of the head of a unit which is there to protect the security of the President, that has nothing to do with the loss of the President's personal money. That, I think, we must be, or at least the panel could assume that President Ramaphosa was aware of that distinction.
Well, I'm not sure I want to accept that he should be assumed to have been aware that if he reported to his head of security, it will not end up with the police. I don't think that is a fair assumption.
Well, it was common cause several years after the event that there was no case opened.
Yes, that is true.
Just put yourself in the position of the panel, or you yourself. Perhaps 8.7 million rand is not so much money to council these days, but imagine, I'm sure I'm being facetious. Imagine you had lost 8.7 million rand.
Let me not respond. No, Justice Rogers, I mean, this is unfair, actually. I know that it's not, but it's really unfair in a matter of this public importance to make a joke like that and then to pass it on.
Let me then continue. 8.7 million rand, if, just as a matter of common sense, if a person loses 8.7 million rand, they would want to know who the investigating officer is and has it been reported to the police. Is there a case pending? And it's common cause that there wasn't.
Yes. But what is the question then for the issue that I'm dealing with in my
I'm trying to just see the totality of circumstances.
Yes.
Then we have, and the panel paid a lot of attention to this, the source of the foreign currency, because it did, in regard to charges 2 to 4, it was not merely the fact that there wasn't a report to the under the Prevention of Corrupt Activities Act. It was the finding of seriousness was that that was a deliberate decision because the President was wanting to keep secret the source of the money. That's the background to where the panel was coming from. Now, in that context, it seems to me it was the President's version, based on what Mr. Ndlovu told him, that an unknown person, who is then identified as Mr. Hamaz, comes to the farm on Christmas Day, just happened to be carrying in cash $580 million, $580,000.
Yes.
Yes.
Yes, and then
he concludes the transaction not with the farm manager, not with the man who runs the buffaloes, Mr. von Willich. He strikes a deal to buy 20 buffalo from the lodge manager.
Yes.
And hands over $580,000 and gets this receipt that we've seen. And then the buffaloes stay on the farm and are never taken.
Yes, I'm still trying to work out where, in relation to the members of the National Assembly, the criticism is.
Well, if there was sufficient evidence of the various matters I'm putting to you, then one might say that the independent panel could legitimately come to the view that in relation to charges 2 to 4, there was sufficient evidence of serious misconduct, sufficient in context to be tested for veracity, not sufficient to convict, but sufficient to go to an impeachment committee. That's what their function is.
No, I submit no, because they did not actually make that finding. What would actually happen if we got where you are, Justice Rogers, is you would have to fundamentally rewrite the conclusions of the panel. That's why I was asking the court to have regard to there are actually several pages, 128, paragraph 204, 137, paragraph 238, 138, paragraph 239, 145, paragraph 264. It's so clear in those paragraphs that what they thought they were doing is to establish prima facie evidence based on information.
Well, we will read the whole report. You'll recall, I think, the acting Deputy Chief Justice put to, I think it might have been to Mr. Budlander, certain earlier paragraphs which appeared to indicate what the panel understood. But I accept, bear in mind, the panel here says, even after hearing the President's version, taking into account what he says, this is not just yet unanswered evidence. Together with his evidence, we take it that there is prima facie evidence. But if you say that that was the wrong test...
Yes. So, in fact, I think we are together, the criticism. If you want me to comment, let me know, Justice Rogers, if you don't want me to comment on the 2 paragraphs that Justice Madlanga referred to.
Perhaps let me just finish and then you can come back and comment on those 2 paragraphs. Yes. We then find that the $580,000 is not put into a safe, and I would have thought more importantly, it is not put into a bank where it would have earned interest at about 2,300 Rand per day. The first thing anybody who receives 8.7 million Rand wants to do is to make sure it goes into their money market account. You don't leave that much money, sorry, I'm now speaking as a matter of common sense. You don't just leave that money either in a safe or under a sofa. I'm not talking about, it's common cause that it wasn't banked and it was hidden in a sofa.
Yes. Well, the question is, what is the role of the members of Parliament in relation to what the President knew at the time?
Well, if they read the whole report, because the structure of the report is before the committee starts dealing with the individual charges, which starts at paragraph 181,
yes,
where it starts with charge 1. It's had what seems, in the context of its report as a whole, to be a very important chapter 12 that runs from page 89 through to 173, including the conclusion in paragraph 171. And that's all to do with the source of the money. And it is clear from the panel at least believed on the information that had been submitted to it that it did not accept that the money had come from the sale of buffalo.
Yes, sorry.
And then, having considered the individual charges, it then in chapter 15 deals with the seriousness of the violation and the misconduct. And it is at that point that it ties in chapter 12 with charges 2, 3, and 4. To reach a conclusion, call it a prima facie conclusion, yes, that the reason why there wasn't a report to the DPCI and the reason why a case wasn't opened and the reason why General Roeder, as it were, off books, conducted an investigation and into the theft was because the source of the money was not legitimate. There was an attempt being made to conceal that was the case.
Yes.
Now, I assume you accept that if there was let's just say prima facie evidence of that. That would be prima facie evidence of extremely serious misconduct.
Yes, I have no difficulty accepting that at all.
And do you say that there was prima facie evidence of that but not sufficient evidence?
Yes, no, yes, I think this is where you and I, Justice Rogers, do not seem to be getting what I'm trying to say. I am saying the finding that must be made by the panel is sufficient evidence. If the panel erroneously fails to make that finding, that is sufficient to vitiate its report. And that is why I've taken the court to where the panel makes that finding. So my primary point is, from the perspective of the MPs that were voting on the report, what they needed to look at, which is what was debated, did the panel act in accordance with its terms of reference? Its terms of reference required it to conclude sufficient evidence. Did they do that or not? They came to the conclusion that it didn't. And on that basis, they said we could not correct an illegality with another illegality. We would vote down the report. Now, it may be that one day, in a criminal case, the president will have a case to answer. It may be that one day, in a different case that comes before the National Assembly, the ANC will take a different position. But on this report, in these findings, the National Assembly was perfectly rational in arriving at the decision that it did.
Now, the expression prima facie evidence does still refer to evidence, but you say the fact that it is prima facie stands on a different footing from its being sufficient.
Indeed.
Now, in the context of the report as a whole, if one reads what the panel regarded as the evidence, and you say, but it formulated it as being merely prima facie, but if you look at that evidence and you say that although it called it prima facie, it was within the context of its function under Rule 129I sufficient, bearing in mind that it's not, as you have said, a veracity exercise. The context is it enough to go to an impeachment committee? What would you understand the precise difference to be between, let's assume for the moment it amounts to evidence. It amounts to prima facie evidence as opposed to sufficient. What do you say is the lower test which has been impermissibly slipped in?
The distinction is better explained by reference to the rules themselves. If you go to page 631, at Rule 129A, and 129A 1 sub A.
Sorry, 1?
129 capital A, brackets 1 small a.
Yes.
So the rule itself tells you that when the Speaker decides whether or not to constitute a Section 89 panel, she must already apply her mind to whether the charge sheet contains prima facie, what discloses a prima facie case against the President. But that changes fundamentally when you go to 633. Sorry, no, it should be 630.
Whether sufficient evidence exists.
Yes, whether there's sufficient evidence that exists.
Yes, sorry.
Yes. Now, what that means is that it is not up to the court, and it is not up to the assembly. It is up to the panel to come to the conclusion that sufficient evidence exists. That's number one. Number two, we know here, we don't speculate, we know precisely here that they did not intend to do what you are suggesting, Justice Rogers, because they specifically debated the difference, and they ultimately came to the conclusion that there is no difference.
There is no difference.
There is no difference. That is the conclusion.
Yes, but that was my question. What is actually the difference? Bear in mind, What the Speaker does when she or he vets the motion is only looking at the evidence put up by the party moving the motion. That's the only evidence at that stage.
Yes.
That's one side.
Yes.
By the time it gets to the independent panel and it reaches its conclusion after it's gone through all the processes it must go through, it has also heard the President's version.
Well, we can...
And now the question is, in the light of all, and bear in mind, it is no longer the Speaker who is, as it were, doing a first cut, and the Speaker may, with due respect to her or him, not have any legal qualifications.
Yes. No,
that same evidence, plus any additional evidence that has now been placed before the committee, plus the President's response to it, all of that, is there sufficient evidence? Now, all of that has been considered. Now, in the context where you have not now only heard one side, but you've received additional information supporting the motion, and you've received additional motion against it from the President. Now you say, in the light of all of that, the formulated test is sufficient evidence. But what I want to know is, what is a lawyer conveying when they assess all of that evidence and they describe it as prima facie evidence rather than sufficient? What is the qualitative difference that you would then understand between those two formulations?
Well, the first thing we would know for sure is that they did not do what they were asked to do, which is to consider whether there is sufficient evidence. We know that as a fact. They specifically disregarded their terms of reference. And in fact, Justice Rogers, you're reminding me of something else. We found the actual terms of reference. They are in the SLA. We tried to submit them. There is an objection from the EFF. But it's important for the court to know the actual terms of reference that the panel had. If the court is interested, we would be happy to circulate those, but we've now got them. So we know for a fact that they disregarded their mandate. They were told they must find, positively find, not hide it in another language, positively find. And that is because, and this is important, that's why it's not a terminological problem. It's important because you are going to send this to lay persons, 400 of them, and you are going to ask of them to make a decision. And what they will have in front of them is they will have the terms of reference they gave you and your report. The first thing that will be glaring is that you disregarded what they asked you to do. And so when you are going to vote on it, about whether you need to proceed with this or not, the first thing that will strike you is that they disregarded the instruction that we gave to them. There is a different question, an analytical question among lawyers, which is, what is the legal distinction between the two? Now, the answer to that is that that distinction is foreshadowed by Parliament itself, by making sure that the Speaker and the panel do not ask the same question. They ask different questions. And on the evidence, the question is, what did the parliamentarians understand the difference to be? What did the parliamentarians understand the difference to be? Now, on that, we have two sources. One, we have Minister Lamula's statement, which is 956A to 956F. What he says are the problems which distinguish information from the evidence. He says, number one, and you can, it's 956C. He says the first problem is the so-called conflation of information and evidence. And he explains that evidence and information in law are two different things. Information is knowledge obtained from investigation, study, or instruction. Evidence is what is legally submitted to a tribunal to ascertain the truth of a matter, and it must have passed the admissibility test. Furthermore, there is no analysis in the report which shows how the information which was provided to the panel was converted into evidence. He goes further.
Sorry, but if I can just pause there. At least Mr. Badnader understood to not embrace the notion that sufficient evidence has any connotation with what's presented in a form that's admissible judicially.
Well, we would submit that it must at least pass some standard. I mean, if, for instance, as I'm making the example of an incomplete statement, It's an incomplete statement. You have no idea what is the name of the witness. You have no idea where was it signed, where was it obtained. It is information, and it may contain crucial information.
See, I did a search of the phrase sufficient evidence in the statutes. It's used many times, and it's very frequently used completely unrelated to what might be admissible in a court of law. For example, in regard to BEE status and qualifications, has the person submitted sufficient evidence of this or that? There's even a reference to, is there sufficient evidence to make out a prima facie case? That also appears in the statute. An auditor must audit to establish sufficient evidence of something. You must submit a bank statement to the master or some other sufficient evidence. We're not talking necessarily about anything that's admissible in a court of law.
Yes.
So a document might be, even if it's not proved through the author of it, might be sufficient evidence or part of the evidence.
Yes, or it may be so unreliable that it should be disregarded because it would not even pass the threshold of evidence prior to its sufficiency. And this is what Minister Lamula said at the time in the meeting, because that is the true test, is what did they understand the difference to be, and can you impugn their understanding of that difference? So it goes further because it shows that there is a qualitative consequence. It was not just about text. Then he says, firstly, on the burden of proof. And it goes to your question, well, they had regard to the president's statement, but what did they make of it? The panel decided to evaluate which version is more probable instead of evaluating whether there is sufficient evidence for a committee to be constituted as per Section 89 of the Constitution. The panel effectively reversed the onus of proof and put the president in a position where he must disprove a version placed before the panel. Then it goes further, hearsay and media reports. The panel did not justify the use of hearsay evidence without the panel itself warning us about hearsay evidence. In paragraph 84, the panel tells us we are mindful of the dangers of relying on hearsay evidence and the caution to be applied in approaching such evidence. The panel failed to lay a proper basis for admitting hearsay evidence. The paradox played itself out in relation to information which related to Mustafa Hazim. It goes on and on and on. Remember, they said it doesn't exist. It turns out he, in fact, does exist.
So there's potentially incompleteness of some documents. There's a complaint about hearsay. Can I just ask you, what, in the context of this rule, what evidence do you say meets the test of sufficiency? Not in the facts of this case. How would you formulate a test that meets the standard of sufficient evidence? What is the level of sufficiency? Bearing in mind that it's not veracity, bearing in mind the limits on the panel's investigative powers, can't receive oral evidence, and bearing in mind that it's a precursor to, let us call it, a full-blown trial before an impeachment committee. So what is sufficient?
No, thank you, Justice Rogers. That is a helpful question. So firstly, we know what is outside. It's what would meet a prima facie, because that has already been done by the Speaker.
I'm not yet clear of that, because I don't yet know. Maybe I haven't fully understood everything you've said to me, but I don't yet understand. Now let's talk as lawyers. I know the 400 MPs are not lawyers, but let's talk as lawyers.
Yes.
In the context of a panel that has heard the input, including the person against whom the charge is made, and then said, we believe this constitutes prima facie evidence of serious misconduct, instead of saying we regard this as sufficient evidence of serious misconduct to justify going to an impeachment committee. What do you understand the difference to be? So, and I think it would be helpful to address that question by first answering the point, what is sufficient?
Yes. Well, Justice Rogers, perhaps just give me 1 second to just follow the pattern I was following to answer you. I'll definitely come to that question. The first point, it goes to prima facie evidence. Now, the distinction I draw between the two, because that's the crucial distinction here in the context of the panel, is it's the sufficiency of the charge itself. In other words, if the allegations contained in the charge were to be established by evidence at a trial, would they constitute an impeachable offense? So that answers the first question, which is what the Speaker has to decide. Then it goes to the second phase. At the second phase, the evidence itself has not been tested
Are you
for
talking
veracity.
the second stage being at the panel stage?
No, I'm saying at the sufficient evidence stage, because there are 3 stages.
Yes. Yeah.
So stage 1 is the charge sheet stage.
Well, the motion, yes.
Yes. Stage 2 is the evidence stage, the sufficient evidence stage. And then stage 3 is the trial stage.
Where something presumably has to be proved at least on a balance of
Precisely.
probability.
Now, on the second phase, and we know this because, as you say, we must talk as lawyers, we know this because it happens a lot in civil trials. At the second stage, what the panel must be satisfied with is that the documents or the information it has would constitute evidence. Secondly, first it must be evidence proper. In other words, it must not suffer from all of the problems that I've been alluding to. Incompleteness, clearly inadmissible, clearly misleading, cherry-picked, and all of those. That's the first question. The second question it must be satisfied with is the question of sufficiency. Now, on that issue of sufficiency, it must at least be satisfied that if this were to be put to a trial, if this were to be tested on a trial, it would be sufficient, there would be enough to take it to a trial, sufficient to find the president guilty. So it's information we can take to a trial. So it's evidence that does not suffer from the defects I've spoken about, but it is evidence that would establish a breach of Section 89 of the Constitution. The third stage, which is the stage of veracity, is now testing the truthfulness of the evidence and not establishing its existence, factual existence, which is stage 2.
If the panel, independent panel, considers that there is evidence which, if nothing more is said, is sufficient to establish guilt, would that be sufficient evidence?
Well, it depends whether it is firstly evidence. If it is evidence...
Yeah, I'm now just step aside from this, but I'm trying to explore what the concepts mean. If a panel, talk abstractly, considers that there is that there is evidence that if nothing more is said, if it is not disturbed, it will show serious misconduct, then is that sufficient evidence?
Yes, it would be sufficient evidence.
Now, at least on my understanding of prima facie evidence, it means the same thing. Evidence which, if not answered, will establish the charge.
No, but not on these rules, Justice Rogers. Not on these rules.
Well, I'm not talking about the rules. I'm talking about the way a panel reasons. It reasons not on the strength of what it read in the ATM's original motion, which the Speaker looked at. It reasons with reference to all the information it had, which included additional information in support of the charges and responses from the President and some of his people against it. Now, on all of that, if by prima facie evidence the panel is saying evidence which, if it is not disturbed, will establish the guilt, it seems to me that it's perhaps gone further than sufficient evidence. Because sufficient evidence means, is there enough to justify putting the President through this process? It doesn't seem to me that that necessarily entails evidence which, if nothing more is said, would actually result in a conviction.
Well,
so prima facie evidence, in the sense you and I perhaps understand it, which in the absence of an answer becomes enough evidence, that might actually be more evidence than sufficient evidence.
No, Justice Rogers, the only distinction I'm making, and I think it's important to keep that distinction because we are dealing with the rules. On the rules, the charge sheet must contain sufficient information on the charge that if there was evidence to substantiate it, there would be a finding of guilt. But the evidence itself, which is the second stage, is not the same thing as a prima facie. What they must then do is this evidence? And if the evidence were to be established at a trial, I suppose sometimes there might be a response, maybe there would be no response. If it is established at a trial, it would be enough to convict, to establish the offense. Beyond that, not just conviction, but seriousness to justify an impeachment. So it's not helpful, with the greatest of respect, to say in criminal law, this is how I understand the standard. in civil practice, this is how I understand the standard. What is helpful is to look at the rule.
Just finally, since you said, did I want you to comment on the passages that the acting Deputy Chief Justice put to Mr. Budland, a particular paragraph I would extract from paragraph 76, which is at page 90 of volume 1.
Yes, it is 75 and 76.
Yes, but in 76, the President shouldn't be required to undergo a full-scale impeachment inquiry where the President has no case to answer. That step may never be taken lightly. It is a momentous act justified only when sufficient evidence exists to show that the President has a case to answer for his conduct.
No, that's what I wanted to answer.
And do you say that that is itself a wrong statement?
Yes, exactly. This is itself a misdirection. That very statement is a misdirection. And the following statement is also a misdirection.
So if, including in the light of what the President himself and his witnesses have told the panel, and the assessment of all of that, the panel says, we have heard enough that we consider there to be sufficient evidence that there is a case to answer now in a veracity inquiry. You say that's the wrong inquiry.
Yes, well, this is not what they are required to ask, because look at the following sentence. The panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the President has a case to answer is considered by the impeachment committee. That we say is the wrong standard. Even the earlier statement is a wrong standard, because it is not a case whether the President has a case to answer. It is a case whether or not, as the rule states, whether or not there is sufficient evidence that there is a violation under Section 89 of the Constitution.
I would have thought, given that the panel has recognized the momentous nature of impeachment proceedings and the fact that its interposition between the motion and an impeachment committee is to ensure that that is not embarked upon lightly, that when the panel talks about whether there is sufficient evidence that the President has a case to answer, it means sufficient evidence to justify the President being required to answer it in an impeachment committee. And I would have thought that that is exactly what sufficient evidence must mean. It doesn't mean sufficient evidence to convict. It doesn't mean it needs to have the same quality of admissibility that might be insisted upon by those who conduct the impeachment inquiry. It means sufficient evidence to expect the President of our country to answer it in an impeachment committee. Now, did you find that formulation objectionable?
Justice Majid said that he was not trying to argue a case against counsel earlier. But Justice Rogers, I think you've heard my submissions.
Well, I won't take offense to that if you don't take offense to mine.
Yes. So, no, I've forgotten about that episode. So it's not going to happen again. But Justice Rogers, you've got my submissions on this, and I hear you. I won't say you're making submissions to me, but I hear the counter view.
Well, let me just put it to you, and this is my final proposition, and forgive me if you think I'm arguing, but I'm genuinely trying to understand what sufficient evidence means in the context of this rule and in the way that the panel used it, because that's central to the reasons why the majority of the MPs rejected it. And what I would want to know is whether, as a matter of law, in the context of these rules, does the panel act rightly or wrongly if it sets itself the test? Is there sufficient evidence to warrant the President having to face these charges in an impeachment committee? Is that an acceptable test?
No, the argument we make is that that is not what the panel did if one reads the report of the panel.
You say it's not what this panel said?
Yes, that this panel specifically found that its inquiry was about prima facie information.
But if we are to determine what is the difference between sufficient evidence and prima facie, if we are just to understand as a court what sufficient evidence means in the context of this rule, you would not quibble with the proposition that it means sufficient evidence to warrant putting the President through the momentous event of an impeachment committee hearing.
Yes, that I thought that is how I articulated the the definition.
And your submission is that that's not the
Yes.
question that the panel asked itself.
Yes, they misconstrued their role because they didn't ask that question.
Thank you.
Okay, let me keep quiet.
Thank you very much.
I think Justice Matop was...
Not that too fast. Mr. Ngugatobi, I've been following the debate between you and my brother Rogers. I want to take you to certain references in the report itself.
Yes, I need to just get... Yes, I'm listening, Justice Matop. I just need to get the full report in front of me.
Well, just find it because I want to draw your attention to certain paragraphs in the report and go through them.
Yes, I've got it now.
Firstly, I kick off with paragraph 72. This is where the panel says, we have compared the terms of reference for this panel to those of the panel established for the removal of public protector. The powers and functions of those panels are substantially the same, save for one noticeable difference. The wording of the terms of reference. The terms of reference for the removal of the public protector require the panel to conduct and finalize a preliminary assessment relating to the motion proposing a section 194 inquiry to determine whether there is prima facie evidence, to underline it, to show that the holder of a public office is guilty of any offense listed in section 174. And they say, by contrast, this panel is required to make a recommendation whether sufficient evidence exists to show that the president committed one of those grounds for the removal from the office.
Yes.
But when it goes further, it conflates this test. It talks about prima facie evidence. If you look at paragraph 75,
yes,
that's where the prima facie evidence comes into the fore. Paragraph 75, paragraph 76, that follows. Now, one is left with a misapprehension as to exactly what test is the panel following and applying. Because clearly sufficient evidence, as far as I understand it, is not prima facie evidence. And in the context in which it has been used, the panel specifically made that distinction in paragraph 74 to say we are now dealing with two distinct concepts.
yes.
But when you read paragraph 75 and paragraph 72, there is a conflation.
Yes.
What are we to make of that?
Well, there are two ways of reading this report. Maybe three, if you listen to Justice Rogers. But I submit that there are two ways of reading the report. The first one is a fundamental misapprehension of the terms of reference. Right? It's told, go and find sufficient evidence. Then it decides it's not going to do that. It will do something different. And that's a misapprehension as to power, and therefore, on the jurisdictional facts standard, Panama is entitled to say we're not going to follow an error of law. The second one is that there is a fundamental confusion in the analysis of the report, because firstly, it recognizes what it is required to do, and throughout the balance of the report, keeps conflating the two as opposed to separating them. On either of them, whether or not what I have tried to suggest to the court is illustrative of a misapprehension as to the correct legal test, or it is illustrative of deep-seated confusion. On either of those two, the Parliament was entitled to refuse to go along with it. The third possibility is what I've been discussing with Justice Rogers, if I understand him correctly, which is forget the nomenclature that is apparent in the report, do an analysis on your own, and what conclusion do you arrive at? if you do your own analysis. Now, that is a very, very dangerous thing to do, because it is not your function to recast the report on behalf of the panel. It is not your function to place yourselves in the position of members of parliament. You have to accept the report as it is, accept the members of parliament as they are, not to rewrite it for them. I don't know how many other reports you'll do this for.
Is it correct that the panel's information, I use the word currently,
Yes.
information regarding the report, the compilation of the report, the information was scanty, or it did not have sufficient information? I'll read to you paragraph 80. Just look at paragraph 80 of the report. It says, we are concerned that we have not been given all the information that is presently available on the Phala-Phala issue. Just stop there.
Yes.
And it lists a various institutions that are investigating the case. In other words, they are saying we are hamstrung in our investigations. We are unable to come to a proper and justiciable finding because we don't have information. Is that assumption correct?
Yes, it is correct, and in fact, it's stronger, Justice Matopa, because it's precisely what Minister Lamola says. Remember that he was criticized by the ATM for taking into account this fact, because he also says, look, you have told us you don't have enough information to come to the conclusions, but nevertheless, you've come to the conclusions. And these inquiries, are pertinent. We now know with the benefit of hindsight. At the time that Mr. Lamola spoke, he only knew of one, which was this Mr. Hazim Mustafa that was said to not exist, in fact does exist. And then he said it's very, very dangerous to put the president through this on the basis of scanty information, because what that really does is that this becomes a fishing expedition. So it's correct that they themselves admitted that they did not have sufficient information.
In the bigger scheme of things, a panel confronted with a report or an investigation of that nature, I don't understand why they didn't ask for an extension.
Yes, in fact,
they make the point somewhere in the report that they are operating under serious time constraints. I will look for the reference.
Yes, in fact, I think it's one of the criticisms by Minister Lamola, who says he doesn't understand. He doesn't understand why they. Oh yes, it's at 956E. So if you look at 956E, 1, 2, 3, 4. 956E. So he says, 2, the panel could have requested an extension of the time period to finalize this report, which it only did once. The Zondo Commission requested extensions till we got tired. All right, anyway, the point is made.
Well, the last paragraph that I want to draw your attention to and ask for your comment is paragraph 82 of the same report. There they said, that said, we believe the truth of what really happened lies beneath the unanswered questions that are foreshadowed by what we are told from the information placed before us. We neither have the tools nor the power to excavate beneath the information that we have been provided with to uncover the answer to the unanswered questions. However, based on what we have been told by the information placed before us, the information that is either common cause or undisputed, as well as inherent probabilities, we are able to make our finding and provide reasons therefore and make our recommendation.
Yes. I mean, it's illustrative of the bigger problem that although the panel claims to appreciate the momentous nature of the function before it, it didn't actually carry through that concern. Because if it claims, firstly, not to have enough information, and secondly, not to have the tools to get enough information, not to even ask for Parliament's assistance, because it would have been entitled to ask for Parliament's assistance, not to even ask for an extension, and then to simply say, no, we'll just make do with what we have. So that we would say is itself, as Minister Lamula pointed out, evidence of a misdirection.
Thank you, Chief Justice.
Thank you, Mr. Mugaitobi.
Thank you, Chief Justice. I'm indebted to the court and to Justice Rogers.
A reply, Mr. Premier.
Madam Chief Justice, members of the court, I don't have the graveyard shift. That's Mr. Katz's responsibility, but I'm going to try and make 6 simple propositions in reply in this matter, which should evidence why the relief sought by the EFF should be granted. The first one is this. The panel made a finding on the evidence presented in front of it, and the ultimate conclusion that it reached is that there is a case for the President to answer. Now, our learned friends for the respondents tied themselves up in knots in trying to rebut that, because every time, like in the debate between Mr. Mugaitobi and Mr. Justice Rogers, when the supposition was made, well, let's read, for example, sufficient evidence every time prima facie is used, would you object? And there was no cognizable answer to that, because what our learned friend Mr. Mugaitobi couldn't distinguish is what's the qualitative and what we would say is the substantive difference between sufficient evidence as relied upon in the rule and prima facie evidence as relied upon by the panel, but not as some free-flowing and free-floating concept, prima facie evidence as they understood to mean the same as the sufficient evidence which they discussed in paragraphs 75 and 76 of their report. And the panel knew, with all due respect, that they were subject to certain constraints. Shouldn't surprise you to know that, because when the panel does its job as the panel, it's acting as what we know in public law language as a creature of statute, or as a delegee that's constrained by the delegation of the superior power to it. And so the panel at various times acknowledges those limitations, and it acknowledges those defects in the rule which constrain its ability to perform its function. And every time it's aware of that, it uses language to tell you exactly the case. And Justice Matopo referred to paragraph 82 of the report. I would say look at paragraph 83 with all due respect at page 92. Because the panel says this: The President has rightly criticized the evidence contained in Mr. Fraser's statements as full of hearsay, in particular information from undisclosed sources. But on that specific point, the hearsay contained in Mr. Fraser's statement, they go on to conclude as follows. We are mindful of the dangers relying on hearsay and the caution to be applied in approaching such evidence. However, we are only concerned here with the preliminary inquiry and not the inquiry itself. So the panel gets dealt an imperfect hand because in the course of the debate today, both the applicants, the EFF and the ATM, and some of the respondents have criticized the rule as containing anomalies or defects or whatever the case might be. But the panel doesn't have the ability to act outside that rule. And so when it does what it does, it reaches the conclusion it does fully cognizant of those limitations on it, but nonetheless reaches the conclusion that there's a case to answer. So if you remove all of the semantic quibbling between the respondents and ourselves about whether there's an appreciable distinction between prima facie evidence and sufficient evidence in the way the panel applied it when they considered the evidence, not the same as when the speaker considered the motion, but when the panel itself considered the evidence, both for and against the contents of the motion. The unanswerable question is that there's a case to answer. That's proposition number one. Proposition number two is this. When the National Assembly came to reject that report, which says that there is a case to answer, they did not say that the panel did not find any of this evidence. They said it was a threshold dispute and that the panel effectively committed an error of law in applying one threshold as against the other. But for all the reasons I addressed in opening dealing with Magwakwa, and I'm not going there again, and having regard to the fact that the panel itself tells you how it reasons these two things, that demonstrates to you, with all due respect, that the National Assembly's decision that there is some difference doesn't even get out of the starting blocks, with all due respect. Because that reason, as we've submitted in written argument and in oral argument, is a distinction without a difference. What the National Assembly did is it latched onto some or other difference that it identified and elevated that to an error of law in circumstances where it is not that at all. And you know what we say about the difference in respect of those things and why they're not different at all. Proposition number three is that to the extent that the panel did, the National Assembly did disagree with the panel, and it did so on a political line of reasoning, which may or may not have been correct legally, but nonetheless emanated from political discussions, or whatever the case might be, we'd remind the court of what this court said in UDM 2017, Volume 5, SA 300cc, and particularly paragraph 79. Members are required to swear or affirm faithfulness to the Republic. Nowhere does the supreme law provide for them to swear allegiance to their political parties, important players though they are in our constitutional scheme. Meaning, in the event of conflict between upholding constitutional values and party loyalty, their irrevocable undertaking to in effect serve the people and only do what is in their best interests must prevail. This is not only so because they were elected through their parties to represent the people, but also to enable the people to govern through them in terms of the Constitution. So we repeat that because we say there may be some world in which a political reason passes legal muster and a political party can rely on that to vote down a report. But we're saying that's not the case here. Because even if this distinction was engaged in bona fide by the ANC, it doesn't matter. Because when the reason is scrutinized as to why the report was voted down, there's no cognizable reason as to why that reason should be sustained. Insofar as proposition number 4 is concerned, and this is on the subject of delay, we would say that the question of delay has concerned the court significantly throughout today's proceedings. We would give 2 references, if we may. The first one is Notiyawa versus Makana Municipality and others, 2019 ZACC 43 at para 49. And what the court says there is that the delay and the extent of the illegality raised in respect of the impugned decision constitutes a weighty factor in favoring overlooking a delay, where, as in Gijima and Tasima 1, the illegality stems from a serious breach of the Constitution. A court may overlook the delay in order to uphold the Constitution, provided that the breach is clearly established on the facts before it. And we would say we're exactly in that territory here, having regard to what's happening. And the court went on to say there, this flows from the obligation imposed by Section 172(1)(a) of the Constitution, which requires every competent court to declare invalid law or conduct that is inconsistent with the Constitution. We ask you to do no more. So to the extent that delay might stand in my way, it's, as I was debating with Justice Matopo earlier, it might be relevant as to remedy, but not as to the merits finding in the way that the court has understood it in Notiyawa. That's proposition number 4, I think. Proposition number 5 is this. Is the debate that we're having here is one about the structure and the competency of the structure to vindicate the principles set down in EFF2. And the reference I gave earlier was to Glenister 2 at paragraph 234. It's actually paragraph 247. And what the court says there, and we say that that logic applies here as well, is that when they were discussing the powers of the investigating judge and the NDPP and determining policy, the court said this: the NDPP may on reasonable grounds refuse to accede to a request. This is a request of the investigating judge. That may place a considerable hurdle in the way of the retired judge's investigation. In short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, has, in our view, serious and obvious limitations. So insofar as our debate on the rule is concerned, we say that's what we're asking you to do, a la what the court did in Glenister. Make sure that the structure limits political interference. And I don't know whether that's time out or whether the court is going to ask me questions.
It means your protected time is over.
Okay, so I've got a last proposition then, subject to any questions being asked.
Make it very quickly.
Yes, thank you, Chief Justice. The last one is this, is that insofar as those reasons are concerned that were advanced by the National Assembly, what we know is that those reasons, well, the ANC as the controlling mind of the National Assembly constituting the majority at the time, what we know is that those reasons can qualify for unlawfulness both as a rationality challenge, that's the absence of the connection to the outcome, and reasonableness, because reasonableness was raised by, I think, our learned friend Mr. Balland or Mr. Ngukhaitobi, I speak subject to correction, that there's a distinction between the two. We say here that where the artificial distinction is as it is, there can be no reasonable outcome in the circumstances because of the reasons we've already addressed in Magwakwa and the other discussion we've had on evidence. May I take an instruction? I seem to be let off the hooks behind me. I don't know about in front of me.
In front of you as well, it seems.
Thank you, Chief Justice.
Mr. Katz?
This is truly the graveyard shift. And I'd like to make 4 points. The first is, if I understood Mr. Bunder's response to Justice Rogers' question on the issue as to whether the administrative law type issues such as Westinghouse, etc., apply to a decision of the National Assembly, his response was, look at Scalabrini SCA 2013. If I understood his answer correctly as to rationality. I'm going to ask the court, when it considers that answer, to consider this court's decision 5 years later in Saripa, where this court, we would submit, qualified the Scalabrini test to say that arbitrariness occurs when there are no reasons. And when there are reasons, then one looks at how the reasons fit in with the notion of the purpose of the action. So Scalabrini, for the purposes of the debate with Justice Rogers and my learned friend, doesn't assist. It's proposition number one. Proposition number two, and the proposition number two is, even though when the National Assembly passes the resolution it does, in this case, it might not be PUDGA, it might not be executive action, but there's no reason in principle why the Westinghouse idea doesn't apply to it. So if the National Assembly, or however one categorizes what it was doing, has three reasons why it does so, and one of them turns out to be rotten, it taints the whole decision. Like admin action, the same principle applies. The third proposition that I wish to make is, I've listened to my learned friends on my right carefully, 4 hours, however long, and I didn't hear a word, not a peep, about the question of paragraphs 192 to paragraphs 194 of EFF2, and the question that there should be no political, well, this court said in EFF2, there should be no political interference in that gap between the complaint coming in, the charge coming in, to the impeachment committee. Not a word in answer. And there are two possibilities. Either my point is so bad that they don't have to deal with it, or it's so good that they can't deal with it. And I submit it's the latter. Just on that point, we're very attracted to Justice Colopin's questioning on the issue of 129I not being as clear as it could be and it should be. And I think Justice Duron picked up on that, and we would add that to our basket on the question as to why 129I should go together with 192, 194 of EFF2. The last point that I wish to make, the fourth point, is this. And here I'm not freestyling, I'm going to freeload from Justice Rogers' debate with my learned friend for the ASC, and it's a serious point. All of the respondents have spoken and presented argument as if the decision that the National Assembly was taking in December 2022 was the impeachment decision, and it wasn't. It was a decision, as Justice Rogers put to my learned friend for the ANC, a decision in that debate where the sufficient evidence exists not to impeach. That's a different test. Forget about prima facie, forget about all these issues. It was a question of sufficient evidence as to whether there should be a trial. And all of the kinds of arguments and the references to EFF2, all the paragraphs that you've heard of references, all related to that last question, to the last step in this big process of impeachment. We don't even get there in our case because of the two problems, the rule being bad and because of the resolution being bad. So we would submit that that which I'd argued before lunch and the kinds of relief that we speak of should be granted. As far as delay is concerned, this is not one of the 4 points. That's the kind of issue which, and I have no instructions, so my client is sitting behind and I can ask him, but it's the kind of point that perhaps, at worst, for my client, I can't speak for the EFF, It could be dealt with how you deal with costs. Some kind of balm against the notion of success. Let's say we win. We succeed in something or other. But you're disappointed with the delay. You might say something about that in how you do. You might. It's wholly within the court's discretion. Say whatever you want. So that's how we would articulate our replying oral submissions. Thank you, Chief Justice.
Mr. Katz, there's something I must correct. It's not that your argument was very bad, it was very good. It was you missed the argument.
Excuse me, I missed it.
Missed the argument about the political interference. Mr. Nukatobi took some time arguing that it wasn't political interference. His argument was that it was based on legal reasons. When he spoke about, let's just, I see you shaking your head, let's just talk about it. You say that those paragraphs 192 to 194 of EFF2 says there mustn't be political interference in those phases, right?
No, sorry, perhaps that was my third point. And
yes, I'm on the third point.
But the ANC only dealt with, if I understood it correctly, and correct me if I'm wrong, the question of the resolution. Didn't deal with the constitutionality of the rule.
Oh, I see.
So I only
with the constitutionality.
I only talk about 129 to 194 as far as the rule is concerned.
Okay.
So it's got nothing. I didn't hear a word about one.
All right. No, I must urge you. It's been a long day.
Okay. All right. Looks like we've reached the end of the long day. Thank you, Mr. Katz.
Thank you.
Court is indebted to all counsel for the submissions. Judgment is reserved. Court adjourns.